Good morning, everyone. I request everyone to please kindly take their seats. It is my privilege to welcome you all to this session. I now will request all the delegates and the Honorable Chair, Honorable Mr. Justice C. Hari Shankar, Judge of Delhi High Court, to please come on the dais. Followed by Mr. Amarjit Singh Chandiok, President-elect of the Bar Association of India, Mr. Jaydev Gupta, Vice President of the Bar Association of India, Mr. Mohit Mathur, Vice President of the Bar Association of India, Dr. Ananta Pujari, Vice President of the Bar Association of India, Ms. Babita Raidu, Executive Director, Legal Affairs at SEBI, and the session rapporteur, Mr. Shaileshwar Yadav. Please kindly take the seats. Before I hand over the mic to the Honorable Chair, I will briefly introduce the session's topic. Today's discussion centers on a simple but an important idea. As India's economy grows and becomes much more complex, the disputes that arise also become more technical and specialized. Issues relating to finance, infrastructure, digital markets, and regulation require not just legal knowledge, but sector-specific understanding of the issues. However, our traditional systems are largely designed for general disputes, which can sometimes lead to delays and uncertainty in resolving those specific issues. This makes it essential to strengthen specialized courts, tribunals, and equally to build deeper understanding of the legal profession. This session will explore how we can better equip both the judiciary and the bar to meet these evolving demands of the high growth economy. With that, I now hand over the session to our chair for the opening remarks. Thank you.
Good morning, everyone. I have with me a very distinguished set of speakers, each of them, without any exaggeration, more distinguished than myself. So, like you, I'm also more interested in hearing them than in hearing myself. And it's just as a matter of form that I am just introducing what the speakers need no introduction. We have 4 senior advocates and Ms. Raidu, who's the Executive Director in SEBI. And I think we could not have had a better panel to deal with this proposition for this session. This is something which we come across every day when we sit in courts. We are now dealing with increasingly complex issues, especially, for example, I sat on the IP jurisdiction for a very long time, and many of the issues which come up before us are so complex that very often within one roster we are not even able to finish them. And many of them need expertise, expert knowledge, for which we have, in fact, insofar as intellectual property is concerned, we have even floated a proposal to have a dedicated panel of IP experts lawyers who can help the judges. Unfortunately, we have not been able to get any substantial names so far. But because of that, this becomes a serious point as to whether having specialized courts who have domain expertise in such subjects would help. But the point is that at the end of the day, our constitutional scheme does not permit anyone to dispense with 226 or 136. So ultimately, the matter does come to a court, and courts are peopled by persons, judges who, though they may have acquired some degree of expertise over a period of time, can't claim really to be domain experts. So unless the groundwork is properly laid, there is available, further dispensation of justice at the appellate and higher levels becomes very difficult. So for that, it is necessary to some extent that we do have people who are at the first or the second tier of dealing with the dispute, who are specialized, who know the subject, and who can deal with the technical and commercial intricacies of the dispute. Again, if there is the bar is also suitably seasoned and suitably engaged in expertise, it does help. But at the same time, we are also governed by the CPC and the various provisions of the Specific Relief Act and other such provisions, and most of the commercial disputes come in the form of suits, and suits have to follow the discipline of the CPC, so they cannot just travel a different path. So it is, to that extent, we also need persons who are experts in basic civil law. So that the synergy that is to be made is always very tricky. And we do have some cases where we find that some of these members of specialized tribunals which have now been constituted in many disciplines, they do deal with it technically on a correct basis, but some of them, they are not so well versed with the specifics of civil law and our CPC and the various statutes. So then on some such ground, then the decrees or the orders become susceptible to challenge. So how that synergy is to be worked out is something which really has to be thought about, and I have no doubt that my esteemed panelists would be able to enlighten us on this, and we will follow the same sequence. So I don't intend to do anything more than request them to share their views on the topic in the same sequence which is there, which was introduced. So I would now request Mr. Chandok, one of our most eminent civil lawyers, maybe the most eminent civil lawyer in the Delhi High Court, to share his views on these issues. Thank you.
Thank you, my lord. If we see the session's heading, it says Judicial Reforms for High Growth Economy, Enhancing Specialized Judicial Capacity and Legal Professional Capacity. So first is, do we have law linked to economy, is the law-making part. So that law-making part is the legislature to look at, to see what is the impact of a particular law on the economic situation. Give you just an example of it. Those who have seen, a new amendment has come into insolvency code, where they say 14 days time from the date when it is filed. Now, on one hand, that is the provision. On the other hand, there is a provision which says you will give an opportunity to the corporate debtor to file a objection. Now, if reply has to be filed, rejoinder has to be filed, that itself will consume 14 days. So the legislature must also see reasonableness when it's passing a legislation, to see, yes, speed is required, but speed kills. It doesn't do anything much. While I personally feel, though I agree that there's some delay on our part, both by us at the bar, maybe even sometimes at the bench, but let's look at it from a different point of view. Today, law schools, I'm sure my Lordship knows, and all my friends know here, they have a specialized course in the law school where they are teaching children to become a corporate lawyer. But there is no specialized course in that sense to teach them what is it, go to court, what kind of trial will you do, and how will it help. So the fundamental that we need to do is, so far as legal profession is concerned, is that I need to change the curriculum at the law school itself. Because I must tell them what is the need. And my own view is, of course, that even if a child has to go, a youngster has to go to a corporate practice, he must practice in courts at least for 3 years. Because that will tell him how we do it. Just to give you a lighter example, a contract said the contract will be between international and Indian party. It will be governed by Indian law. The arbitration was governed by English Arbitration Act. The criminal law was uncitral. Place of arbitration was Malaysia. So how do you reconcile the whole thing? And the second part is that how do we bring, even the bar must have an ongoing learning situation. Because law is changing every day. What we used to have 20 years ago is no longer today, as Lordship rightly said. That today the complex questions are coming. In fact, I remember when my Lord Justice Pratibha Singh was practicing, a question arose was, we said, I am a person who wrote lyrics, I still have a copyright, person who made the soundtrack has his own, and the person who actually made songs is third. Ultimately, it took a little time, but we got those through till we got these amendments made, and now everything is recognized. So therefore, the question today is, sir, how do we make that capacity as specialized? An High Court judge, every 6 months or 1 year, maximum capacity changes, roster changes, he goes to another bench. But to give you just an example of it, we had a very eminent judge, H.L. Anand, and I was before him in a design matter. He said, look, I've never seen Design Act. First, read the provisions first. So that is what we need to look at, even at from a bar point of view, and both only. In Delhi is an exceptional situation that where bar and bench has blended together to bring that institution. But many places, they find it very funny. How could you talk like this, the Honorable Judge? So therefore, I don't think that relationship is also required to be built in order to build your capacity. Laws are coming, but we are not looking at what law is going to interfere with that. Now look at this. IBC says, I am supreme. Overriding effect. RERA says, I also have an overriding effect. RERA also provides what? That you have a scheme, you have a plan by which you reform those projects which the builder is making. So is the IBC doing. Now, if the matter is already before RERA, RERA is already developing that project, where is the need to go to IBC? So these things require today to be ironed out by the legislature itself. Because overriding situation, every act provides I'm overriding. So how do you meet that? I understand sometimes we say act came later, therefore it is. So a very interesting question arose. An act was enacted first. It got the assent also earlier, but actually came in operation later. So question is, when will it come into effect? So these are actually positions, and with all humility at my command, probably Delhi, Bombay, Bangalore, Chennai still has something to look at. I think the first and fundamental change that, in my opinion, we need to bring is that we must bring original sites to the High Court, at least to some extent. Because the complex questions are coming, and our honorable judges are not trained so well. A youngster coming with, now we have again imposed that condition of 3 years. It's impossible for him to understand, not that he's not capacitated, he'll get experience. But within High Court, all these things must reach the High Court today. Because in case I have to look at investment point of view, I have to see what I have to get to the people. Therefore, time has come, at least commercial courts must be in the High Courts all over the country. Rest, I think my friend will join me. Mr. Jaydev Gupta.
Thanks, sir, for your address. And just apropos what Mr. Chandok just said when he mentioned about this case in which this dispute arose about lyrics. That reminds me of a very recent case which had come before us, which was incidentally an appeal authored from a judgment authored by Justice Pratibha Singh, where what had happened was that A.R. Rahman, he composed a song for a film which was called Veera Raja Veera in some Tamil film. And the Dagar brothers, Fayazuddin Dagar, etc., they filed a suit saying that this song is based on Shivastuti, which was composed by us. Now, under the Copyright Act, the first owner of copyright is the composer, no one else. And the composer is the person who composes the song. So, the Justice Pratibha Singh gave an interim order saying that there is clear copy. And if you hear the two, prima facie, they appear to be, one appears to be copied from the other. But on the aspect of whether the Dagar brothers were actually the composers, there was no direct evidence. So what she said is, since there was a large volume of material to show that they had rendered the song, I'll treat them as composers and give the interim injunction. So when it came to us, we said yes, on the copying part, we don't find a case to interfere, but we felt that a composer and a person who renders the song are two different persons. And unless there is proof that they are the composer, we can't give an injunction in their favor. So we said mere rendition is not enough, and we stayed it. The matter went to the Supreme Court, And ultimately in the Supreme Court, they didn't decide either this or that. And they said that there the Rahman came up with a compromise saying, all right, we'll give a recognition that they are the persons who rendered the song, who sang the song initially. So ultimately the issue didn't get resolved. And the order of the Supreme Court itself says, without going into whether the single judge is right or the division bench is right, we are just settling it on these terms. So this issue again looms large as to when you don't have a proof of who is a composer, to whom do you give an injunction. So that's another aspect of how, so many issues are very technical, and grappling with them is always difficult. So far as keeping the original side with the High Court or increasing or decreasing, etc., as a sitting judge, I can't say anything about these things. Anyway, I now give it to Mr. Jaideep Gupta to provide his comments. Thank you, sir.
Good morning, ladies and gentlemen, and thank you very much for coming on a Sunday morning here to listen to whatever we have to say. It's not an easy job. It was difficult for me also to arrive. We are discussing specialized judicial forums as a mechanism for improved delivery of justice, particularly in the sphere of economics, because the overriding theme of this conference is the growth of this nation. Now, everybody is aware that there is a substantive aspect to it, and then there are procedural aspects to it. Apparently, the topic that we are addressing is more procedural in nature than substantive. But they are all interlinked, so if I may be permitted to make one small observation, and on the substantive aspect, you see, the basic law of economics, as far as we are concerned, is the Contract Act. And yesterday, our President, Mr. Prashant Kumar, had dealt with it in his opening remarks to say that it was time that we looked into the Contract Act to see whether it is satisfying the requirements of this nation or not. Now, it is certainly true that it has never been looked into in that sense. The English Act, the English law which was codified as part of our Contract Act, but from which there were major departures, by the way, by the English codifiers themselves. The English Act has been itself modified multiple times in the last 50 to 70 years. Sometimes they do not, of course, have a Contract Act, but the law has been amended by bringing into effect various acts. For instance, unfair contracts, contract terms, misrepresentation, mistake, etc., have been specifically dealt with in individual statutes to modify the common law, which is the basis of the English dispensation of justice in this area. However, we have to be conscious of the fact that the Contract Act is timed in a colonial time, but it is not a colonial legislation. The Contract Act covers those principles of English common law which are used for resolving contractual disputes. As it happened, the same principles got adopted everywhere in the world except in certain countries and in certain societies which were maybe tribal, or the nature of the society was a little different. But by and large, the commercial community across the world accepted the same rules of English common law in the sphere of contracts. So therefore, while it may require modification based on our requirements, it should not be rejected altogether for two reasons. One is that it is not designed for India, not designed by a Westerner for India. And secondly, because the people you're dealing with in contracts are across the world and they need a common system. Without a common contractual system, it would become impossible to do international trade. And this is the reason why international bodies have come into existence to settle specific terms of contracts. The ICC settles specific contractual terms, said, let us say, in relation to shipping and marine insurance, etc., etc. So keeping in mind that we have to maintain this uniformity across the world, we can look into our legislation to see where differences have to be identified and dealt with. Now here there is a very important thing, and that is that the basis of contract law is that the courts will not interfere with the terms of the contract. Contract terms are entirely in the domain of the parties. This is where the aspect that Mr. Prashant Kumar had mentioned yesterday, the uncertainty. Mr. Prashant Kumar made a distinction between the certainty, which is the main feature of the English Contract Act, the Indian Contract Act as enacted by the English jurists, and the requirement of dealing with uncertainty, as he has spoken of the monsoon economy. Now, monsoon economy was of course our economy at one time. Thanks to elaborate arrangements which have now been made, the impact of the monsoon is far less on the Indian economy than it used to be. This has mostly been achieved by harnessing the irrigation potential of river waters and making sure that water is available across the year for that purpose. For that purpose, there have been dams built, there have been connections made between rivers, etc., etc. So therefore, even though it is a seasonal economy, and many other countries in the world also have seasonal economies, certainty is still a very necessary part of it, subject to this fact that you have provisions for dealing with genuine uncertainty. And one example of it is that some years back, the Indian producers of electricity had bid for power contracts where they had relied upon the fact that they had mines in Indonesia. Because Indonesia at that time was allowing international entities to own mines in their country. So based on that, they had bid. Before these things could go online, the government in Indonesia changes, and when the government changed in Indonesia, the new government said that no, international leases will not be allowed to continue in our mines. So therefore, the basis on which Indian producers of electricity had made their bids to Indian entities were affected. Now this is a genuine situation of uncertainty which has to be somehow dealt with. It was dealt with because in the field of electricity, there is in fact a specialized legislation, there is in fact specialized courts, and the principles of commercial law, particularly contract law, have been moved away from in one aspect. And that is the court which deals with such contracts, that is the electricity regulatory authority followed by the appellate authority, had the power to modify the terms of a contract. So see, this is a wonderful example where the original premise of the English law, namely that contracts cannot be interfered with by courts, are modified to take care of uncertainty and other features to allow the court to somehow modify the terms of the contract. Now this has been done by way of a regulatory act, and of course it is a part of regulatory law. Regulatory law is a mixture of commercial law and administrative law. So we have in that sphere, wherever regulatory laws have been enacted, which is many specialized spheres, electricity, telecom, gas, etc., etc. In all these areas, it has been possible to already achieve something that the Honorable Chief Justice had mentioned yesterday, namely bringing in public law elements into private law. This has already been achieved. In this country it has been achieved internationally. Now, so therefore, the substantive part of it will depend upon these aspects. You have to identify which legislation are required to be modified because of particular reasons, and when they are modified, how are the courts going to deal with it. When we come to procedure, the most important change in Indian law has been the Commercial Courts Act. The Commercial Courts Act modified the Indian Civil Procedure Code in many respects. And it did so for the time being for the limited purpose of the Commercial Courts Act and the disputes which go to commercial courts. At the time when they did that, commercial courts could only take disputes up to 1 crore and above. Now it has come down to 3 lakhs. That's a different problem. There are various pluses and minuses of that, which I shall not go into at this point of time. But please note that here we actually have a specialized jurisdiction. And this specialized jurisdiction has the most interesting feature of section 5(2), which requires the Chief Justice to nominate for as judges of the commercial courts persons who are well versed in commercial law. So here is a situation where a specialized judiciary is being encouraged in the legislation. But more importantly, the procedure has been changed. If you look at the objects and the discussions around the objects of this legislation, it was said that this is a model modification of the Civil Procedure Code. If it works, then it is quite possible that those model modifications will be generally applied to all other civil disputes also, because they are actually, some of them are extremely useful for the purpose of expediting litigation, etc., etc. For instance, it has specific reference to case management. One of the only ways in which litigation can be expedited without compromising the quality of the justice is case management techniques. Case management techniques are specifically referred to in the Commercial Courts Act. It is of course true that apart from a few high courts, maybe Delhi is one of the finest examples of having made full utilization of the Commercial Courts Act, but there are hundreds of courts in this country who do not look upon the Commercial Courts Act as an important addition to the Indian jurisprudence, and therefore they completely ignore these things. Case management is expressly brought in the Civil Procedure Code by way of a modification when it comes to commercial disputes. It says, for instance, that this is how you will prepare your pleadings. Now, for the first time, the best practices relating to pleadings are to be found in a legislation. It says, for instance, that the court will narrow down the issues and only allow those issues which are relevant to the case to be gone into. So these are all methods. These are procedural methods given in the Commercial Courts Act to improve the judicial functioning in the area of commercial disputes. And so therefore we have an example of what we need to do. Now, having dealt with the procedural aspect, one of the main aspects of procedure, though an understated and unstated aspect of it, is the functioning of the judiciary. Now, the functioning of the judiciary is rarely dealt with in any legislation or in any law. But the purpose here is to suggest that there should be methods by which the judiciary can train itself better in specialized areas and therefore bring down the time and achieve greater consistency in the delivery of justice in these areas. And of course, these areas are extremely complicated. Anybody who has done an electricity case will tell you that it is that if you are approaching it for the first time, you will require a whole lot of initial study to understand even the terminology which is involved in the matter. So if you can get over that by using a person who is already versed in it, or using lawyers who are already versed in it, then of course it is things will go so much faster. There will be greater understanding between the lawyer and the bench as to what the effective proposition is that is being put forward before them. So then this kind of training is required, and it is only in the case of the Commercial Courts Act that, because of section 5(2), it has been emphasized that the judges having that special capacity should be sitting in those benches. There are various methods by which the judiciary will get trained. We have excellent institutions for judicial training in this country, all the way up to the highest level of the judiciary, whether we call it training or upgradation or whatever they are comfortable with. There is enough infrastructure now available for the judges to acquaint themselves with different spheres which are coming into play today. Let us now take one instance of how the British have handled this topic in recent times, and this will also bring up another very important aspect. The British in 2017 brought together by a process all the tribunals which were dealing with business and property laws of complex nature into not one tribunal but into one space. Please see how important this has become. All the upper tribunals are now to be located in one space, one building. When you do that, employment tribunal, business and property related tribunals, construction related tribunals, all these tribunals are to be located in one place. Having done that, they then say that you can utilize the expertise of a judge in one sphere in another sphere. Because now the complexity is such that judges who are well trained in one may require to actually work with somebody else who is well trained in another sphere. By putting them all into one space, it has become possible for the Chief Justice to have benches constituted with judges crossing over from one specialization to another. And this is so important because let us say in a particular instance, there is a complicated mixture of employment law and commercial law and other laws which are required to be gone into. So you can create a bench of that tribunal, the upper tribunal, which will take care of all these things. So therefore, the most important aspect of this 2017 amendments which have come into the UK legal system is that specialized judges will all sit together and they will be available to each other for discussion. Now, you see, every lawyer is capable of doing a specialized subject because some of his skills are basic and general, which he shares in common with everybody. Then in addition to the skill that is general, he develops a specific skill by knowing a set of concepts, knowing a set of principles. Now, it's not necessary for a lawyer to specialize only in one. There are many fields which can come together, and there is no difficulty with doing specializing in more than one field, even though that appears to be contrary to the word specialization. But in our profession, we can happily do different kinds of regulatory work without there being any conflict and without there being any lack of understanding. So therefore, lawyers can have a basic skill and they can develop an additional skill. Similarly, the judiciary, which is effectively a larger part of the legal community, are trained in general principles which are very useful in the solution of special situations, and in order to get up with the special situation, they can receive appropriate training and appropriate experience. One of the first examples of this was in the 1980s, I think, when judicial review proceedings in the UK High Court was given to a judge or a group of judges only, because it was a discretionary jurisdiction. This is judicial review of administrative action, because at that stage, and even today after Brexit, it is not possible for the judiciary to set aside any legislative action. So there is no judicial review of legislative action available in the 80s, and again it is no longer available after Brexit. In between, because of the European Convention and the European Court of Human Rights, etc., there were certain legislations in the UK which could have been challenged, but now it cannot be again. So therefore, in that jurisdiction, there was what was known as judicial review of administrative action, and that was under, at that time, Order 53 of the Code of Civil Procedure, and now it is a section in the Supreme Court's Act there. So therefore, what they did was, in the 80s itself, they said that the same judge will continue to deal with this subject over a period of, let us say, 2 years. If he does so, the discretion which will be exercised in order to deliver justice will be uniform. It is not as if 5 different judges are dealing with judicial review, and so therefore when it comes to the exercise of jurisdiction, there are 5 different views, all valid views, but nonetheless 5 different views which lead to 5 different outcomes. So very early on, this kind of experience-related specialization was thought of in the UK courts. We are also doing that because now India has a huge range of specialized tribunals, specialized courts, etc., etc. You are all familiar with the company jurisdiction has specialized inputs from technical personnel, etc., etc. It's another thing that our specialized courts have not always worked very well, but that is something which has to be worked on, and everybody has to see what we can do about it. So since I am speaking to a group of lawyers on behalf of the Bar Association of India, so to speak, I would like to end by giving what seems to me to be a blueprint on how we can proceed to strengthen the judicial and the legal profession for the purpose of deciding specialized disputes. First of all, we need to classify the subjects which we are dealing with or which our courts are dealing with, and then identify those amongst them that require specialized approach. IT is one, electricity is one, company is one, which are already in place. Like that we can decide, as Mr. Prashant Kumar had said, that there are many new areas which have come in. Investment may require a particular approach, etc., etc. So first of all, you need to identify those areas in which specialization or specialized courts are required. Then you have to survey the law, the substantive law, which relates to that sphere, and see where those can be improved. Thirdly, you have to survey the procedural law which governs it and then suggest changes in that. So after that, you will think about what are your existing mechanisms for training judges, and if that has to be improved, what are your existing methods of training lawyers, and of which there are none, which will then have to be introduced, and then you will go on. And here is a point which I wish to make, that yesterday also we have discussed this in some detail, that there are endemic delays in the system. The endemic delays in the system can be tackled in various ways. One aspect is greater familiarity with the subject. Another aspect is following up the subject through the same set of judges. But there is one very important aspect which we need to emphasize, and I will conclude with that. The legal profession is not ethical in this country. They delay matters not because there is any genuine reason to delay the matter, but for strategic and tactical reasons. So long as we continue to do this, it will be impossible to expedite the adjudication process. If you are interested in delaying the adjudication process, then there are enough tools to help you to do that. So we will have to work not only on the technical training of lawyers, but we will have to work on the ethical training of lawyers. It must become absolutely unacceptable for a lawyer to say that I am prepared to take an adjournment on the ground that it will be an advantage to my client. That must stop. With those words, I'll hand the microphone over to the chairman.
Thank you, Mr. Gupta. That was an extremely insightful address, and your suggestions towards the end, they are very well taken, and I hope that they would be followed up in the right spirit by the right persons. There are only one or two small takeaways which came to my mind after I heard Mr. Gupta. One was, of course, that how many lawyers and how many judges would be willing to say that we are agreeable to undergo training is another issue. There is an inherent, we find difficulty whenever we want to send judges for any kind of training. There is a mind block. After all, we are judges. I mean, what training are you going to give us? That's one aspect. But that's another aspect. There's one very interesting, since Mr. Gupta took up the point of the Commercial Courts Act. There is a provision in the Commercial Courts Act which has always kind of mystified me. I don't know whether anyone has. So we have Order 13A in the Commercial Courts Act, which is in fact one of the provisions which has been introduced specifically to the Commercial Courts Act to make things fast, which provide for a summary judgment unlike 37 of the CPC. And if we see Order 13A, Rule 3, which says grounds for summary judgment, it is a very interesting provision. It says the court may give a summary judgment against a plaintiff or a defendant on a claim if it considers that A, the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of defending the claim. That's one aspect. And B is very interesting. There is no other compelling reason why the claim should not be disposed of before recording evidence. So recording evidence and trial has become the residuary, and a summary procedure has become the norm under Order 13A, Rule 3B. I am not very sure how legally correct that kind of a dispensation is, to say that the court will resort to a summary trial if there is no reason why it should not do so. So why it should proceed to evidence? That seems to actually be charting a course somewhat diverse from the CPC. But I didn't find, though in all these, we have sat on the commercial jurisdiction for quite some time, I didn't really find that this provision has come up for any serious examination by the courts. But it is definitely a provision which is intended to make things fast. Now I would give the mic to my close friend, Mr. Mathur, to further enlighten us on these aspects. Thank you.
My Lord Justice Hari Shankar, Chair for this session, Mr. Chandok, Mr. Jaideep Gupta, Anindita, Babita, my fellow speakers, and in fact, far more distinguished than I am on this subject. Good morning. Borrowing from my colleagues who spoke before me, we need not be reminded that India's justice system stands at a constitutional crossroads. We are no longer dealing with merely delay, but a structural mismatch, according to me, of 21st century situations with a 20th century legal capacity and the framework. The real challenge, according to me, is not merely to redesign the institutions, but to strengthen subject matter expertise. Since all my other colleagues who have spoken have taken care of the civil and commercial laws, I would rather restrict myself to my own so-called domain specialization. That's the criminal side of it. It's common knowledge that if an economy has to grow, the legal framework and the justice system, the justice delivery system, should be not just robust, but speedy, so that it instills a trust in everyone. Now, since Mr. Gupta has already taken everyone and discussed the commercial courts, the fact that in how a situation happens and how the lack of expertise has been discussed by Justice Hari Shankar and Mr. Chandok, that a complex question finally reaching the Supreme Court did not get a verdict, but got a compromise answer. Similar is the situation on even criminal side. The pendency of cases is largely almost 90%, as per the reports of Supreme Court Center for Research and Planning, is in the district courts, nearly 90%. And for any high growth economy, as we wish to target India for achieving $10 trillion economy, we need to have resolution of not just the commercial disputes, but even the criminal disputes swiftly while protecting the rights of both the accused as well as the victims. Parliament over the years recognized this problem and created several special courts and fast-track mechanisms by establishing not just the commercial courts, but even special CBI courts, special PMLA courts, the legal system. Every statute of criminal law is now being also attached with the economic consequences thereof, or any economic gains that people have had, and to somehow restrict the flight of that money from India, to have that money brought back into the economy through either attachments or other proceedings. So it is in that context that it is important to realize that this fast and predictable dispute resolution is actually not possible with the generalist courts. The courts which are trained, the judges who are sitting on the benches are trained for the basic criminal law and basic civil law. So merely saying that this pendency will be reduced by increasing number of judges is also fallacious, in my humble submission here, that this persistent shortage may contribute directly to the backlogs, but you need specialized domain knowledge both to the judges as well as to the lawyers, who can then quickly address the issues and get them decided. So we should have, in my opinion, specialized tribunals, but with the councils also having specialized knowledge. Otherwise, the entire purpose is not served if either the council has the knowledge and the judge, the bench officer doesn't have, or vice versa. Either which way. So this legal complexity, if you see it in today's context, what we find is that there are the GST issues where the agencies act in a super fast manner. Rather than to decide the issue, they arrest the person and have him pay some deposit, some amount of money, because by the time the classification happens in the tribunals, whether it is rightly classified, whether the input tax credit has been taken properly or not, he deposits some money and the government is happy with the revenue that it has collected, either by way of extortion or by way of arm twisting, or in the normal, proper fashion which it should, under normal circumstances, do. The new problems which have come up in the last 25 years of this century are the technological issues which have come up. On the criminal side, we have faced problems on the bitcoins and this cryptocurrency issues, where the tracking of it, the understanding of the whole process is alien both to the lawyers who are defending, to the lawyers who are prosecuting, and to the judges who are sitting to decide the issue. Similar are the issues when it comes to data protection, the data privacy, artificial intelligence. Today there is another problem of deep fakes. All these require constant upskilling, as they say in England, that we need to upskill ourselves to the different technological advances that have taken place. Upskilling is necessary both for lawyers as well as for the judges. And sir, you rightly said there is a reluctance in going in for an upskilling program or a session. The bigger reluctance is when it is being explained to the bench officer that the particular aspect is a technical aspect which requires not just your normal BNSS as it is now, or the normal criminal law understanding, but a more finer nuances of it. So it's vital, especially in the criminal side, on the white collar crimes, where we must understand that there is a paradigm shift from the old criminal framework to the new BNS and BNSS. The BSA, which is now the substitute for the Evidence Act, the Bharatiya Sakshya Adhiniyam, it's a tongue twister by itself. It includes now different kind of things. The digital evidence rules are framed. The chain of custody of the material seized is there. The call detail records have to be examined properly. Now, an issue incidentally happened that on the basis of the call detail record, in one of the cases, since it's an ongoing case, I don't want to name the cases, the call detail record was shown to show two people having their signals from the same tower. Now, tower location was found to be covering a radius of 250 meters. Now, if anyone understands mathematically, a 250 meter radius would go on to be nearly 1 square kilometer or a little more. Nobody was willing to understand at the initial stage that the tower location being same does not mean that the two people were together. Now, for a crime to be done together or to be done in conspiracy with each other, or to say that these two people, these two accused were together at the scene of crime, it was easy to show to the judge initially by the prosecution that this is the same tower. You see the location, CDR location. Now, despite all technology, what comes from the nodal agencies of these telecom services is not a pinpointed location, but that tower location alone. It was only in the evidence that the matter came up and the question was asked, how much area does it cover? And then two different distance of nearly half a kilometer was shown to the witness that is this also covered by this tower? He said yes, and both the places were shown to the judge on an iPad with a zoomed the maps, Google Maps and the Earth map, Google Earth map, to show that on road it would be more than half a kilometer if they were so far apart, possibly, because on the criminal side you need to only show the preponderance of probability. If there is a doubt created, the chink in the armor. But the man suffered 2.5 years in custody because X, who was supposedly his co-accused, was in the same tower location. Now, these things the prosecuting agency could have sorted out initially itself when a person is interrogated. So when the technology has given you that much leverage and you understand it, then it is always better rather than people suffering on that account. Now, there are certain international jurisdictions which have gone ahead and dealt with these special courts and multidisciplinary courts. An example of it was found in drug cases in the state of Washington. An experiment was done, and they started involving a program from, instead of incarceration, to supervised programs where the supervision was done of different accused by judges, prosecutors, defense counsels, social workers. And in 2 years' time, it was found that there was lower reoffending, fewer psychiatric hospitalizations, and fewer jail days. The model showed that the felony rearrests had gone down from 40% to just 12%, and the saving to the public exchequer was nearly $7,000 per participant or per person who was involved in it. These show that even in technical criminal matters, if you can adopt to specialized schemes and specialized aspects which are basically localized to that particular offense or that class of offenses, much can be done faster and in a better way, because that will give the trust back to the society. The society will have the trust in the system. Today, as falling from my colleagues and fellow speakers, that there is a tendency to delay. It's not just that there is a tendency to delay by the lawyers, but the fact that many a times ignorance and not understanding the aspect also causes this. Now, such a scheme, as I was reading about it, I found that the entire emphasis was to categorize these felons, the drug felons, into different categories, who were first-timers, who were regulars, who were into trafficking, who were connected with syndicates. They made different categories and dealt with each one differently, not painting everyone with the same brush. Unfortunately, in our country, the law does not give us that much indulgence, though today the BNSS, which has been made last 2 years back, from 24 it became effective, they have kept all these things into account, that who are the first-time offenders, but that's unfortunately only to the extent of the bail and release of the person. But while dealing with them while the trial is on, or to see even if the trial is complete or if the man has confessed to his guilt and pleaded guilty to the charge, whether he still needs to be sent to jail or there could be some reformation for him. All these things are necessary today because the millennials are jumping to make more money faster. So in that respect and in that race, they are committing crimes which are technologically aided. Artificial intelligence is used. Now, very few officers investigating cases understand it. Very few lawyers understand all the technical aspects, and very few judges. In fact, that pyramid is very, very narrow when it comes to the adjudicators. So, when the government is considering all these aspects and remodeling the laws, they could also remodel these laws further. Unfortunately, at that point of time, as a representation we had given from the Delhi High Court Bar regarding the SOPs and all which need to be built when the new laws are coming in, and there was a gap of 5-6 months from December 23 till 1st of July. But I feel it was not even read by the people concerned and people in authority. Timelines today need to be also fixed, because if we need to go for a high growth economy, we need to tell the world that, look, if there is an institution of a case, it shall be dealt with the fastest, and you are sure of a resolution of it by the end of X period. We have developed all that in CPC, we have developed all that in commercial courts. When it comes to the criminal side, none of it comes forward. The dates, adjournments are given not just, sir, for the counsel's asking, but most of the time the bench doesn't have time. So it's, I may sound cynical or critical, but then that's the reality. An aspect which has been developed, sir, in UK, and that's for everyone's facility, is a concept of having specialized counsels, domain specialists appointed as deputy high court judges and deputy district judges. They have given a tenure. Generally, it's fixed from 15 to 30 sittings in a year, and they are asked to deal with a particular class of cases. They have all the powers which a person who's a permanent judge has. He has all the jurisdiction, but since he is specialized in that area, he is expected to deliver justice faster and finish as much pendency there can be. There was a discussion in the past regarding appointing ad hoc judges But then we are talking of ad hoc judges, as per the constitution, would be those who are retired from that court or equivalent court. We can consider having specialist counsels, at least a breath of fresh air, because counsels would have a different perspective, and they can be appointed to deal with all these aspects, which will help. As far as certain priorities, in my opinion, on the criminal side which are required, are filling up, that's need not be said, filling up the posts which are vacant. There is a concept in the West where counsels, specialized counsels, are to aid the investigation and to aid the bench. They don't have powers to deliver a justice, any kind of judge. What we have as law researchers are young counsels aiding the judges. But here, seniors are given one or two cases, obviously with the restriction that they will not be party to either side, and the usual undertakings. They aid the judge or they aid the investigation. Minor part of it is borrowed in our system by the different investigating agencies having forensic auditors coming in for economic offenses. Those forensic auditors are CAs who are empaneled, and they come in and help you in understanding what's gone wrong if there's an economic crime. But what I am talking of is aiding the system itself from outside. So these counsels have nothing except to aid the judge, bench, or in the process of investigation. That helps in faster understanding of it, because there is a back room where you are made to understand the issue and then deal with it. The third aspect is more legal aid counsels to be recruited, because in the trial courts, what we find is you have a limited panel. That liberty which, sir, when we had our younger times in the bar, legal aid was not just from one NLSA, this NALSA or DLSA, but the legal aid would be picked up from counsels who are sitting in court. When that spectrum is increased, obviously the people who are better prepared, you don't have to go there and say, okay, we just got the file and I am not ready, or give me time, or I am engaged in some other case. So these, what used to be amicus curiae, so it's not just amicus curiae, but legal aid giving them some kind of remuneration as well, and allowing a larger number of people to help clear the backlogs. Then, as I just heard, that the law colleges, they try to train people more for corporate law. Unfortunately, nobody wants to come. The cream de la cream doesn't want to enter into criminal law. Perhaps it's not as lucrative, and the running around and gestation period is higher. So there is a reluctance that this is probably the dirty work. But people don't realize that ultimately any part of the system, if it is not taken care properly, the system will not work. And criminal law today is resorted by people to get faster resolution, because the sword is hanging on everybody's head. Those, and my own experience, more than 70% of our cases are actually civil disputes, which intelligent drafting and better legal acumen, they convert it into criminal law by adding two words, dishonestly and fraudulently. Every third line will have that. So unless and until we mentor the younger lawyers to take up this task, maybe on a tenure basis, 3 years or 4 years, and then they can be let loose wherever they want to go. They can develop their own independent practice or otherwise work on this. And they, when they and the younger minds, the millennials, are faster on understanding and grasping technology, they obviously can lay it threadbare. They can take it out, tell people, and say actually whether there is a crime or culpability involved or not, or is it something which is innocuous. But merely because people of our ages do not understand technology, we find that there is a dark shade everywhere. But that should not be permitted. What, in the end, I would like to say, I've already taken a lot of your time, is that backlog and this high growth economy business is not just merely numbers. We need to have a more firm, stable, and a robust system as a whole. Because what we are leaving behind for our future generations should not be so much of a burden that they first spend half their lives in clearing this burden rather than developing the economy on a whole. So on the criminal side, this special economic offenses, benches, trained prosecutors, legal aid support, multidisciplinary systems, supporting from the outside the investigation and the judicial system, besides technically trained judges, are the only way I feel that a system can deliver justice timely and institutionally credible. Thank you.
Thank you, Mohit. And just about one of the points he had mentioned about training, I'm just reiterating, I'll actually tell you the facts. According to our patent rules, we have, because in the Delhi High Court, honestly speaking, I don't, if there is a technological patent case which comes before us, then most of the judges are clueless about the intricacies of the technicality involved. For example, we have sometimes patents about, electronic telecom patents where someone says there is a sine wave and there's a cos wave and these interact like this. Now, judges, we try to grapple with it to what extent we can, but it's next to impossible to really understand it. And for this we had this provision in our rules to recruit some trained patent expert advocates who could assist the judges, and we even gave the remuneration, made the remunerations quite handsome, almost $1 lakh per person who could come. And we had one exercise of recruitment where I and another judge sat. We interviewed about 21 advocates who had tried to come in as experts, to be recruited as experts, and we could select only 2. 19 of them knew nothing about it, and they candidly acknowledged on being probed that we are only coming to learn. So we said, we are not taking you to learn, we are bringing you to teach us, right? And out of those 2, one opted out, and the other one is also, his term is ended. So now we are again back to square one, we have nobody. And we really don't know how we'll get. So recruitment of persons is a very, very big task. And most persons prefer to go in for practice than this kind of a, technical expert panel. So that is a major challenge. We don't know how we will handle it. And now I just hand over the floor to Ms. Pujari, Dr. Pujari, to just enlighten us with. Thank you.
Good morning, everyone. Thank you to the chair. Thank you to Bar Association of India once again reposing the faith on me and giving me this opportunity. Frankly speaking, before I go to the written script, which I somehow had to prepare in the night after receiving a call from the chairperson of the session, I thought I'd better be prepared. And it's a very important and a happy day for me, personally speaking. About 2.5 decades ago, when I started my journey on my PhD, and I conceived the idea of how about looking the Constitution as an economic document, I had nobody to talk to. Today, I have got a full auditorium, those who are ready and willing, and they're listening and talking about it as my colleagues, as my friends. I'm here to learn from them, and they're here to listen to me. it gives us great sense of collegiality and great sense of comfort when we can discuss things in an open environment, and it is no more an idea whose time has not yet come. Thankfully, after 2.5 decades, it's an idea whose time has already come, and we are here to discuss and take it forward. In fact, at that time, the only person that I could go back to, most of you would remember Professor Sathe, the great administrative law expert. So I had no idea who to reach out to. I flew down to Pune to meet him. Sir, where should I begin? And he referred me the Carolina Products case from US. And he said, why don't you start reading from there? Maybe you'll land up somewhere. Those were the days, and now here we are today. So now going back to what had emerged since yesterday, how we as an association, and please pardon me if I keep changing my hat as a speaker in this panel and as somebody who is deeply and associated with the Bar Association of India in institution building for future. So I have got my views, my opinions, my suggestions as how we can move forward. I'll keep changing the hats frequently, hopefully seamlessly. What we deliberated upon yesterday was, I want to start today with a proposition that might sound a bit provocative, but that's what emerged from yesterday's discussion. That the economic trajectory over the next decade, our greatest risk in India isn't inflation or fiscal slippage, really. Our greatest disadvantage has been a clogged and unrust legal system, which discourages, or at least, to put it mildly, which does not really encourage us in bringing an economic prosperity and growth for our nation. If that is what concerns us, then it's definitely something that we need to think upon in greater detail. Let's first understand what is actually at stake. We are setting our sights on becoming a 10 trillion economy, going by the theme of the conference. Just last year in May 2025, we concluded a landmark free trade agreement with the UK projected to boost bilateral trade by 25.5 billion USD annually. Negotiations with the European Union are moving towards an equally consequential deal. India's strategic positioning tells us very clearly that we want to center ourselves as the node or the central node of global supply chain. In fact, there were questions to that effect yesterday, a magnet for a long-term capital and a rule setter for the industries for tomorrow. Having said so, however, the road for that is not at all simple, and we did realize the challenges that were discussed yesterday as well as today in the panel. It requires capital and investment, no doubt about it. However, they do not flow automatically, but comes on a precondition of certainty and predictability, as very interestingly put by Mr. Sharma yesterday. Enforceable contracts, predictable regulations, efficient dispute resolution are not just nice to have terms. They are absolute preconditions that we must have. And right now, on those preconditions, we are definitely falling short. There is a clear acknowledgement to that effect, even in the panel today. As of early 2025, our courts are carrying a staggering backlog of over 50 million cases. Between 2020 and 2024, that backlog grew by nearly 20%. Meanwhile, judicial vacancies, however, hovered around 33% in the High Court and about 21% in the district courts. Now, you might have heard that in 2024, the national ease clearance rate for the High Courts, in fact, averaged around 94%. That might sound really, really reassuring for those who want predictability, certainty, and fast progress in disposal of cases. However, the courts are disposing of cases faster than before, but there is a catch over there. The absolute backlog is still growing. So in terms of absolute numbers, it's a difficult task to constantly juggle and pedal together so that we are able to not fall below the average numbers. We are running faster, only to fall further behind. That's really is one of the challenges that did emerge during the course of discussion. The situation in our specialized tribunal, which was mentioned even today, there was reference to commercial courts, there was reference to DRT, NCLAD, there was reference to APTEL and all of that. A rigorous analysis of the Daksh report that estimated that roughly about 24 lakh crore in commercial dispute, about 7.5% of India's GDP is trapped across just in 10 commercial tribunals. which is a huge, huge number and is definitely a matter of concern. The DRT alone carries over 215,000 pending cases, and 18 states and 2 union territories are yet to establish DRT. I'm not sure of the recent position because this is as per the 2024 affidavit that was filed by the central government before the Supreme Court. The Company Law Tribunal, on the other hand, is dealing with chronic vacancies. As we all know, the matters are going on filling of the vacancies in judicial forums, and there is an over-reliance on contractual staff. Even those matters and PILs are pending before the Supreme Court, and there is no serious adjudicatory body that can sustain with these challenges. As discussed in earlier sessions yesterday, 24.7 lakh crores, or the 7.5% of our GDP, is tied up in pending cases. So we need to address that. When capital is trapped in litigation, it drains the lifeblood of our credit markets. With every passing month that an infrastructure dispute lingers in the docket or in the courtrooms, the lender confidence erodes and the cost of capital spikes. A 10 trillion economic ambition cannot rest on a foundation that is as shaky at its institutional or foundational level as this. Further, as economy is accelerating, it is altering the commercial conflict zone. We are seeing novel disputes emerge across highly specialized frontiers. The digital market, which was again referred to yesterday, the digital market regulation, algorithmic trading, generative AI, as well as complex cross-border mergers and infrastructure financing issues are emerging more frequently than before. Because these disputes are irreducibly technical, generalist legal principles are no longer sufficient, and we do acknowledge that. They require adjudicators equipped with deep sectoral fluency. While I'm referring to the deep sectoral fluency that we must all emphasize, and we are doing that, what we need to understand is we are talking about really the muscle memory of the system. We as individuals work intuitively through our muscle memory. We as lawyers, yesterday on the AI session, Mr. Vibhu Tripathi was referring to the difference between AI and the human intervention. And he was saying, oh, there you can get the data quickly. But when there is a human intervention, you have got a recall value. So here, when we are talking of systemic changes, we are talking really of the building the muscle memory of our system for economic growth. Our traditional courts, however, are generalist courts. They were designed for a different era. Asking them to adjudicate the most sophisticated commercial dispute of the 21st century is a paradox. I say this not as a critique of our brilliant judges on the bench, but while simply recognizing that traditional institutions were built for a different purpose. We would never expect a world-class cricketer, or Tendulkar or a Kohli or somebody, to be getting medals in Formula One race, despite the fact that he might have got extreme talent as a sports person, the discipline and rigor of a sports person. So therefore, specialization do matter. Think about what this means in practice. A judge who hears a heinous case on Monday, being argued by none other than Mohit Mathur, has to hear a matrimonial dispute on a Wednesday and a complex commercial matter on a Friday, and cannot be expected to develop a deep field-specific understanding of that subject. Judicial expertise grows through sustained engagement with a particular area of law. So are we really providing scope for sustained engagement? That's something that we need to reflect upon. The exact time, at the same time, the logic applies to us at the bar. We need to introspect ourselves as lawyers. A lawyer appearing before a DRT one week and a consumer forum the next cannot develop the forensic depth needed for the high-value commercial litigation. Without specialists at the bar, even the best intentioned specialized bench will be helpless and will be underserved because they will have no effective assistance from us, the lawyers. When a legal system fails to provide speed, predictability, and specialist competence, sophisticated commercial parties do what rational actors always do. They take their business elsewhere. In fact, yesterday, so many examples of that were shared with all of you. The International Chamber of Commerce preliminary 2025 statistics are absolutely telling. Over 2,500 parties participated in the ICC arbitrations last year, dealing with an aggregate pending caseload of about 299 billion USD. India is actually back in the top 10 nationality ranking, reflecting our growing commercial footprint. However, what's a matter of concern is a recent Queen Mary University survey found that about 87% of the respondents prefer international arbitration for cross-border dispute than us trying to resolve the dispute in India. In simpler terms, our most sophisticated commercial disputes are being resolved maybe in London or in Singapore, but definitely not in Delhi, Chennai, Kolkata, or Bangalore. We consistently underestimate the cost of this migration. On a lighter note, in fact, we as lawyers, we did talk about, Mr. Jaideep Gupta did talk about the lawyer should be more ethical, but just on a lighter note, we as lawyers in this entire process of migration of litigation, to say the least, lose fees. And what more do we lose? We lose a deep sense of jurisprudence that could have evolved with the interaction. When we try to wrestle with the facts, which are complex, when we try to wrestle with law, which is unknown, so therefore, what we could have wrestled with was our ignorance, which we failed. So the loss is not merely in terms of our fees, but also a great deal of jurisprudence that could have developed in-house that did not. So the loss is real for us as lawyers, as stakeholders in the administration of justice, and as shareholders or stakeholders in the growth of our economy. These inputs take decades to build. Therefore, the expertise that we are talking about, it cannot be merely imported. Our international trade agreements cannot come into force. Cross-border dispute will only multiply. The question isn't whether they will arise, but the real question is how and where they will be resolved. Now, to think that India is doing nothing is not correct. We have all been referring to the Commercial Courts Act, the Mediation Act since yesterday, and the digitization of our court system, e-filing system. The Chief Justice did refer to the 4 acts that were inaugurated yesterday. So there has been a constant endeavor to resolve these issues. We should recognize the political and judicial will that produced them, but we also have to be honest about what hasn't really worked till now. In reality, the Commercial Courts Act largely redesignated existing civil courts. We changed the label on the door without injecting the substantive expertise that the label implies. We cannot simply declare a court specialized by way of gazette notifications. We all know whenever there is a PIL with the court and we demand, under this act, the court is still not designated in these states, the immediate action that comes is a government notification, declaring the existing courts to be a specialized court, without even analyzing whether it has the capacity to deal with the matters that we are assigning it. Similarly, the mandatory pre-institution mediation mechanism that has dramatically underperformed has become counterproductive. As per the Economic Advisory Council's data, based on 2 commercial courts in Mumbai, 97 to 99% of these mediations were non-starters, because parties chose not to participate. And of those who participated in the process of pre-litigation mediation, about 50% were only successful. So what made the system fail? The law was brought in, but what made the system fail? What did not incentivize the stakeholder in the justice administration system not to participate? This is because the parties, the lawyers, and the mediators have no incentive for mediation. Especially, I'm talking about the commercial mediations. To mitigate this, we have to change. Probably, we need to have a rethink on the incentive structures of successfully mediating disputes or resolving disputes. Training pipelines and professional culture that governs the mediation landscape of this country. Now that we have contextualized what ails the system or why we are bothered, what are really the problems, as a bar association, as lawyers, as judges, what can be done? How to improve the system? So what lies ahead is a humongous challenge, but it's not unsurmountable. That's what I believe in. So let us begin with one basic truth about our courts. They are not just merely temples of justice in the notional sense of the term that we keep referring to. They are also extremely crucial and important so far as getting our economy together and attaining the 10 trillion economy that we are talking about. So they have got a very, very important role to play in that, because every contract that gets signed, every insolvency that arises, every commercial dispute that passes through the courts, it passes through us. They are holding the weight of our economic ambition. Our legal system already carries enormous responsibility, and we all have contributed to it. Now is the time to strengthen it. Step back, reflect, and strengthen. I want to share 7 adjustments to the process of strengthening, so that I'm talking about the adjustment because I know it's very difficult when a set pattern is there. Imagine when we are referring to the training, we are still trying to nuance it in a manner so that it is not offending, as if accumulating knowledge is inviting ignorance. It is actually dispelling that. However, it's all about our practices, patterns, biases, and how do we deal with that. So there are a few adjustments only that I'm suggesting. Number 1, could we have a permanent commercial rosters? We already have it in few places, but let's think it can be in all hierarchies, it could be in all places, because I find there are certain gaps there. So let us start with our quotes. Capacity building means permanence. There is a knowledge base which is getting created, which is sustaining there, and which is going to contribute to the economic growth. Judges learn commercial law best when they stay with it long enough, I emphasize long enough, to master its fine details. Project finance, construction contracts, intellectual property, and digital markets demand steady engagement. Creating permanent commercial roster in High Court and Supreme Court helps judges to develop focused expertise. How many of you, the Supreme Court practitioners, would remember, once upon a time we used to have a social justice bench. It came, it went. How it came, how it went, we do not remember. So if it is one-off incidents, maybe it doesn't really help, but if something that stays there for a little longer for us to understand and appreciate the benefit of it, and dismantle if it is no more serving the purpose, definitely helps in institution building. So creating permanent benches definitely helps. But what is required really is, because it also adds on to confidence building measures, which is at the core of it. Because what seems to be lacking really is faith in the system. If that be so, then what is required to be done? Confidence building. The question and the answer are two sides of the same coin. So if confidence building measures are required, we need to see it for a sustained period of time. And at the district court level, however, we can do something more similar, as in high courts we have got the commercial side. Let us build dedicated commercial courts and recruit officers for this stream. They must not be deployed for all matters such as criminal roster or a matrimonial roster or any such thing. In fact, interestingly enough, on a side discussion with some judicial officer the other day, I got to know more than hundreds of judicial officers in this country are doing jobs which are not necessarily adjudicating dispute. So let's because they are assigned some administrative roles, they are assigned, in fact, technology roles which they are not even experts of. So therefore, let's have dedicated officers even at the district level. Number 2, judicial appointments for the future. We all know, in fact, informally we all knew. I remember about 30 years ago we were doing some research on who becomes a judge. Thankfully, a few years later, I think it is Junior Gadbois who has now written a book on who becomes a judge. You can actually analyze the statistics, see the pattern and say, if you fulfill these criteria, you can become. That may not be fully correct, and it has got its own concerns and considerations. However, the judicial appointment is something that we need to look at. Our judicial appointments must evolve. The nature of dispute has changed completely. There have been a paradigm shift with focus on generalist practice to specialist practice. So we must encourage the specialist lawyers, and maybe if there is a diversity quota, there is a specialist quota that need to emerge, and emerge consciously. Number 3, we are talking about strengthening the bar. The strength of our judiciary depends on the strength of our bar. The most sophisticated client may need sophisticated advice in terms of your expertise. So the Bar Association of India can take the lead here. It can partner with regulators such as SEBI and others and actually have professional training programs and modules. This can ensure that talented lawyers from all regions can participate, and not only in these big cities that the lawyers get all the opportunities. When every aspiring commercial lawyer can access quality training, we'll see a stronger and more inclusive bar. Realigning, the number 4 adjustment that I'm seeking from all of us is realigning mediation incentives, as I've already referred, so I'm not going to refer to it all over again. But mediation can only be made effective, and it can be resolved, it can be used as a respectful means of settling disputes and disagreements, provided it is being deliberated open. And so therefore, we need to focus on this. Number 5 is embracing the AI literacy. It has been spoken about yesterday in greater detail, so emphasizing on that may not be required today. Number 6, national, and this is one of the most important suggestions that I would put before you for consideration. If we can have something like the National Consortium for Law and Economic Research and Practices. Each new field of law, whether it is cryptocurrency, data protection, blockchain, or whatever, it requires novel approaches. And therefore, in this context, having a national consortium for law and economic research and practice becomes essential. Such an institution would serve as a structured platform for collaboration among judicial academies, regulators, as well as us, the bar and the bench. The objective would be to foster informed consultation, coordinated policy input, and institutional synergy. Through periodic roundtables, we can discuss and deliberate issues of greater concern, which are technical in nature. At present, meaningful interaction between the members of legal profession and the economic regulators remains limited, as it was mentioned even by none other than Mr. Suman Bedi yesterday. And largely through conferences like today that we are getting these opportunities. It would provide advocates with a credible avenue to engage with regulators, understand evolving compliance framework, amongst others. In turn, the regulator would also benefit by interacting with the other stakeholders in the system. The last adjustment that I am going to refer to, and with that I would conclude, is strengthening the infrastructure and the funding. This is an age-old problem. Finally, as we all know, even while in my discussion with the Bombay Bar president yesterday, we got to know many a times there are allocations, but those allocations only remain in paper. These are for announcement purposes. The trickling down effect of actual deposit in the bank accounts, making it available for spending, is not a reality. And therefore, the infrastructure development, both physical and otherwise, as we have already spoken about, the intellectual capital needs to be developed. Now at the end, let us end on this thought. When a large infrastructure dispute stays unresolved, the market feels uncertain. The delay affects investment, it affects pricing and confidence. As India signs new trade agreements, cross-border dispute will naturally grow. We can and must provide the forum to resolve them efficiently rather than allowing those disputes either stay unresolved for years or migrate to other jurisdictions. These are not the solutions that we are really looking for. The foundations are already there. We need to only strengthen them. If we build our institution with care, we can unlock the next phase of our growth, and I have no doubts about it. Our commercial courts can become amongst the strongest in the world. The systems are ready. It is only a matter of choosing to make them work together and choosing to work now. Thank you so very much.
As we have already kind of overshot our time, and our next chair, Justice Anish Dayal, is sitting there giving me meaningful looks. So I'll reserve any comments, anything to say now, and I give the mic to Ms. Rayadu to give us her insight on this aspect.
Honorable judges, chairmen and members of the Bar Association, members of the legal fraternity, ladies and gentlemen, a very good morning or good afternoon should I say to all of you. Till now you have heard the voices of the jurists, the senior members of the bar, the policy makers, and even that of an industry person. I bring to this forum the perspective of a securities market regulator. All have discussed the India growth story. The GDP growth estimated at approximately 7.4% for the current fiscal year, world's fourth largest economy, poised to become the third largest within the next few years, and that we should aspire to sustain 8% annual growth to realize the vision of Viksit Bharat by 2047. I will add to that a facet of the success story of our capital markets. Nearly 13.6 investors holding over 22 crore demat accounts as on March 2026. Yet for all this extraordinary momentum, there is a structural vulnerability that threatens to become a structural constraint. And that vulnerability lies in the gap between the pace at which our economy is growing and the pace at which our legal system is evolving to support that growth. We all know that growth creates disputes. Disputes demand adjudication, and the speed, the quality, and the predictability of that adjudication determines whether capital stays, whether enterprise expands, and whether citizens retain faith in the institutions of the Republic. And as a participant in the legal and the economic ecosystem, I have witnessed every day the consequences of both the strength and the frailties of our legal and judicial architecture. And these frailties are not peripheral concerns, but first-order economic constraints. It is against this backdrop that I wish to speak the perspective of SEBI on, firstly, the issue of specialized judicial capacity. Financial markets operate in real time. The settlement cycles for equity trades in India is now T+1, the fastest in the world. When we detect market manipulation, insider trading, or fraudulent or unfair trade practices, we must act swiftly, often through interim orders that freeze assets, restrain trading, or disgorge unlawful gains. These orders are appealed before a specialized tribunal, presently based in Mumbai, with jurisdiction over the entirety of India, which also decides appeals against the decisions of the pension regulator, the insurance regulator. And these decisions of the tribunal are then appealed before the Supreme Court. The very existence of such an appellate structure is a recognition of a fundamental truth, that adjudication of complex financial disputes also requires domain expertise that generalist courts may not always possess. And yet, this tribunal, operational since almost 3 decades, functions today with a single bench in Mumbai, presently with 1 presiding officer with judicial expertise and 2 technical members, both drawn from the executive. I ask this question to this forum: is a single bench, however competent, with the majority of technical members, adequate for the weight of responsibilities it carries? The experience of the NCLT offers a cautionary parallel. Conceived for company law matters and perhaps some SEBI matters, it became the frontline forum for the Insolvency and Bankruptcy Code, one of India's boldest economic reforms. But the results have been sobering. The average insolvency resolution now takes around 713 days, more than double the statutory ceiling of 330 days. Only 2/3 of the sanction posts, largely drawn from the executive, are filled. Over 10 lakh crores rupees in value remains locked in distressed assets, and 30,600 cases remain pending, which, as per the Economic Survey 25-26, could take a decade to clear. When the Commercial Courts Act of 2015 was conceived, and my learned panelists have dwelt on this issue as well, I will talk numbers. India's ease of doing business ranking climbed 79 positions because this act envisaged dedicated courts, strict timelines, mandatory pre-institution mediation. but implementation remains uneven. In several states, these courts lack dedicated judges, case management hearings are perfunctory, and the culture of adjournments persists even in a forum designed to be adjournment averse. Surely there are solutions to these issues. The other half of this equation is the constraint in the legal capacity, despite 17 to 18 lakh advocates enrolled in bar councils across India. Allow me a personal recollection before I proceed. When I began my legal education, the landscape was different. Every capital of a state had in effect one institution of note: Government Law College in Mumbai, the Faculty of Law at Delhi University, the University of Calcutta at Calcutta, Usmania University, my alma mater, in Hyderabad, to name just a few. Those were the anchors of the legal education, and the options were few. Today, the transformation is remarkable. I see a growing number of students in the Indian Law School that, as per the QS World University rankings, are competing credibly on the global stage in ways one could scarcely have imagined. Yet, for all these strides, there is a glaring gap that I have observed firsthand. The near absence of specialized subjects such as insolvency laws, securities market regulation, competition laws, taxation, in most school curricula. Disciplines that effectively define the legal landscape of a modern economy. They receive remarkably little attention in the formative years of a young lawyer's training. I say this not as an abstract observation, but from personal experience. Over the years, I have had the opportunity of mentoring several law students who have interned with me, and also have arranged for special lectures in all these colleges across the country. But let me be clear, these students are an exceptionally bright and motivated group of young people. But it has struck me, time and again, that many of them have never developed an understanding of basic financial laws. What has surprised me even more is something far more basic, that a subject like administrative law, which is the very cornerstone of regulatory litigation before specialized fora, appears to occupy a peripheral place in the working knowledge of most students. If such foundational subjects are not firmly in place, the specialized ones have nothing to build upon. This is where I believe academia has to step in to bridge this gap. I also wish to share another observation drawn from my brief years in litigation. One I believe remains equally true today. A large number of advocates continue to confine their practice to conventional criminal and civil dispute resolution. Very few venture into what one might call the specialized domain. I do not say this as a criticism, because every professional has a right to chart their own course. But having reflected on this over the years, I believe two factors are at play, structural factors. The first is the law school itself. If a subject is never taught, or taught only as a peripheral subject, as an elective, it cannot be expected to inspire a career. The second is a perception, not entirely unfounded, that specialized practice offers, at least in the earlier years, neither the volume nor the financial incentive that conventional litigation provides to sustain a dedicated practice. Now, between the unfamiliarity bred by our law schools and the economic calculus, the career options that most young lawyers inevitably make, the specialized bar remains thinner than it should be, and thinner than this economy could afford. Some food for thought. My other concern, the appointment made to specialized tribunals, when adjudicating bodies are perceived as extensions of the state, the executive establishment, without the domain expertise that was the very justification for creating these specialized forums. competent professionals from the private bar and the specialized practice are understandably reluctant to seek appointment, and the legitimacy of their orders becomes the first casualty. Consider this contrast with the UK. Most practitioners in the financial area who are elevated to the bar bring with them a domain expertise, depth of domain expertise, if I may say, or practice-tested expertise that no amount of generalist administrative experience can replicate. In Singapore, the judicial salaries are benchmarked through independent market surveys against relevant private sector talent pools to ensure that the state attracts and retains its fair share of talent. And the result is a judiciary so trusted that commercial parties across Asia voluntarily choose Singapore as their forum. I am, of course, not advocating that India mirror Singapore's compensation levels overnight or adopt the English structure. Our realities are different, and I am conscious of those constraints. But the underlying principle admits of no exception. When we pay those who adjudicate significantly less than what they would earn by practicing before the very fora that they are asked to preside over, the outcome is predictable. We will fail to attract those who excel at the bar or create conditions where integrity is tested by inadequacy. Neither outcome serves India, and we need to work hard to resolve this concern and constraint. Another issue that certainly burdens the economy is the voluminous litigation by the government and its related institutions. I am happy to highlight that on its part, being cognizant of this issue, SEBI has taken every effort to reduce this litigation the last few years, which I shall demonstrate with data. During the last 5 years, many entities filed 3,694 appeals before the appellate tribunal against the orders passed by SEBI. 2,331 were decided in SEBI's favor and 543 against SEBI, of which SEBI filed an appeal only in 200 cases. We accepted the tribunal's verdict and we moved on. In the current financial year 2025-26, SEBI has filed only 19 appeals before the Supreme Court. This, ladies and gentlemen, is not an accidental outcome, but a result of a rigorous internal review mechanism put in place in the recent past to scrutinize every adverse court order before its decision is taken whether or not to invoke appellate jurisdiction. Only when the impugned decision interprets the securities laws such that it affects market integrity, compromises investor protection, or could lead to regulatory inconsistency, we appeal. But if appeals are filed against SEBI, they have to be defended, or we have adopted an alternative enforcement mechanism wherein those can be settled. And this can be done through a policy that we introduced in 2007, initially as a process to further reduce litigation, but which found so much favor even after judicial scrutiny that it became a statutory settlement framework applied with adequate guardrails by SEBI. And through this policy, I am happy to state that over 15,700 applications involving multiple entities, which in effect could have meant maybe thrice the number in enforcement proceedings or litigation that are pending before different fora, have been settled, provided that the interest of the investors or the market integrity is not compromised in the process. I am happy to say that the judiciary has been extremely supportive of this endeavor, because clearly every one of those settlements is a case that did not burden a court, did not consume time in adjudication, and did not lock up capital in uncertainty. We, in effect, adopted this quiet but powerful instrument to aid judicial decongestion. I also believe that technology is a wonderful economic tool, and at SEBI we have expended a considerable amount of time and effort and money on this area. But given the constraints of time, I cannot dwell on this further, other than to add that its application has proved to be a great enabler. This would hold true even for the judicial and legal architecture. I am certain that the collective effort and the corrective effort by the legislature, the judiciary, the executive, the bar, the academia, and indeed regulators could yield results when in all areas we move beyond diagnosis to action, beyond prescription to implementation, and beyond aspiration to accountability. Thank you. Jai Hind.
Thank you, Ms. Pujari. Thank you, Ms. Rayadu. And we will be now closing this, but just before that, just a few closing comments. There are several things I wanted to say, but we are very short of time. So I just want to put one thing on the table. There has been a universal kind of concern voiced by almost all the speakers about pendency and of how we have such a volume of cases, litigation pending, and that's a major issue as to why cases take time. And in fact, Dr. Pujari had suggested this concept of dedicated commercial courts. You see, that is something which would be very utopian if we can do it. But it is a practical, I think, I can frankly say a practical impossibility. For the simple reason, one which is a very uncomfortable reality is, if one bench continues to hold a commercial court for an extended period of time, all kinds of apprehensions begin to surface, and I don't want to go into it, but all kinds of things start. People start saying, why is this bench continuing with this roster for so long? And then things become uncomfortable. That is a harsh reality. The second reason, which is more practical, is, you see, we have to be conscious of the fact that every litigation is not commercial. I had before me, in fact, there's a very recent decision I have authored about 2 weeks back. I forget the name of the party. It dealt with a pharmaceutical patent for a product called semaglutide. Now, this patent is expiring in March. It must have expired by now. An interim order passed by the single judge. Now, once that patent is expiring, everyone can use that patent. A plaintiff who's claimed to have delivered, to have manufactured that patent, said someone is misusing it, filed a suit asking for an injunction. A single judge did not grant an injunction, and appeal was filed. That appeal came before us in December. So I asked them that, look, in another 3 months, in any case, everyone can use that patent. What really is there in this matter for us to interfere? At the highest, we'll ask the defendant to maintain accounts and say what is the amount he's gained by using it. What is the sense in spending court time in passing a detailed judgment, because these cases take 1 day to argue, sometimes 3-4 hours, then you pass a 100-page, 80-page judgment on it, and ultimately by the time you do it, the patent is almost expired, and that actually happened. We ended up delivering judgment towards the end of February. March, the patent expired. Now, but the problem is, we don't have a filtering system in our country. Everyone can file an appeal. We had an appeal before us where the dispute was about patents about whiskey caps. Someone said, I have got a patent for a whiskey bottle cap which looks like this, the other one's cap looks like this, and then for 1 hour there was an argument before our bench on which cap is, whether this cap is the same as that cap. So actually then when I asked the senior counsel who was arguing that matter, I said, look, it's a very intellectually stimulating exercise and very well argued. But then I have before me on my roster, because I have a multiple roster at that time, I have a case of a DTC driver who was thrown out of his job 20 years ago. He is without a job for 20 years and he is waiting for his case to be heard. And I said, look, today our courts are visually available everywhere. if that poor driver logs on to this proceeding and finds that the court for 1 hour is hearing a dispute between whiskey caps, whether this is like this cap is similar to that cap, what is the faith that he as the citizen is going to have in this institution? So when we talk of dedicated commercial courts or dedicated this court or dedicated that court, our problem is we have such a volume of litigation in which many of them may actually be a persons who are in the depth of poverty, that if I really wonder how far we can even prioritize commercial litigation. At the same time, yes, commercial litigation has to be given. Commercial Courts Act is intended to ensure speedy resolution of commercial disputes, and that is another side of it. So it's a very, very delicate balance. I don't know, with our volume of cases which are pending, and actually it's contrary to what many others say, I actually think we should stop thinking of backlog now. Because let's be realistic, even if every judicial post in this country is filled at every level, I don't think within the next 30 years we can clear the backlog. That's not taking into account cases which are going to be filed in that period. So backlog, thinking of backlog and eradicating backlog may be actually unrealistic. The best thing is to try and decide every case that comes before us as well as we can and as expeditiously as possible, keeping in mind priority of cases. Maybe one answer is to prioritize matters and see that cases which are not so important are not given priority. Anyway, but it's been a very enlightening discussion, and I am very grateful to all our speakers. I have learned a lot more, I think, than as much as all of you, and I'll take home a lot from this discussion. Thank you very much, and thanks a lot for calling me as the chair in this session. Yes, ma'am.
I know we are running behind the time, but we are practicing at district courts, and I have one question only, that pre-mediation in commercial court is just we see it as a formality, because there is no effective pre-mediation, sir, and no one is interested and no one takes full interest in this. And I have experience since the courts, established at Taluka court. When the courts were at this of 1 crore, I fully agree with you, Amarjit Singh sir, because when the jurisdiction was of 1 crore rupees and the courts were at regional center, commercial court, so it was very difficult to file the case at, there were a lot of queries, and even registrar will not number the case. We have to go to the honorable sir, and a number of queries. And now what we see, when the jurisdiction is given to all taluka courts, sir, the capacity building of judges and lawyers, make it compulsory. I will request our President Prashant Kumar sir that BAI must pass the resolution after organizing this seminar and symposium, and we must pass the resolution, because we see what we see. Sir, in my one case, I saw that there is no affidavit which is prescribed in Commercial Court Act, sir, and the answer was given, the affidavit is not done as the COC and register was on leave. Sir, so this is my question, that make it compulsory, pre-mediation, compulsory. Yeah, question, no sir, this is, we have experience, so effective pre-mediation, not only formality, what should we do, sir?
See, the simple answer to that is we've got 12A itself has an escape clause. Unless that escape clause is removed, it will never become compulsory. 12A says that if it is urgent, then the court can dispense with it. And I have my own reservations on how 12A is being interpreted by courts, but Because now what's happening is we had those two judgments, first of Justice Joseph, followed by Justice Sanjeev Khanna's judgment, both of which have clearly said that it should be ordinarily treated as mandatory. But at the drop of a hat, people just say that this is urgent, and so courts are allowing, without even asking for a reply from the other side, courts are allowing dispensing with pre-institution mediation. Perhaps that needs approach change. I fully agree with you on that.
Thank you, friend. We're starting with our next session without a tea break.
एक आहे सुबह पीपीटी इधर से करना है पीपीटी ऐसा हाँ फिर यहाँ लैपटॉप ऑन ठीक है पहले मैं शुरू कर देता हूँ फिर बाद में यहाँ पे दिख जाएगा वहाँ से ओपन करने के बाद यहाँ से हाँ वो ठीक है
सर वो इन्हीं से वहाँ से स्टार्ट कर देगा, स्क्रॉल यहाँ से होगा।
ठीक Very good afternoon to all. We are about to start this session because I was supposed to start this session by saying a good morning, but now it's a good afternoon. So please come. In this session, I request the Honorable Chair, Honorable Justice Anish Dayal, so right in today's session, we will be having Honorable Chair, Honorable Justice Anish Dayal. Then the speakers we are having, Mr. S.S. Naganand, Senior Advocate, Vice President of the Bar Association of India, Mr. Vikramjit Banerjee, Senior Advocate, Additional Solicitor General of India, Mr. Nitin Thakkar, Senior Advocate, President of the Bombay Bar Association, Dr. Uday Prakash Varunjikar, Vice President of the Bar Association of India. I request all the speakers to be presided via Honorable Justice.
He's coming.
Yes. And we have a session rapporteur, Ms. Ashna Bhargava, who is a legal consultant from Law Commission of India. I request all the speaker, Honorable Chair, and all the speakers to join. Thank you so much, sir. The today's session is about arbitration, mediation, and dispute avoidance ecosystem, building institutional trust, credibility, and framework of visible excellence and impartiality. When I think about this trust, the only some 4 lines of Kavi Dinkar hovers in my mind. Those are, दो न्याय तो अगर आधा दो, दो न्याय अगर तो आधा दो, पर इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम। दुर्योधन वो भी दे न सका, आशीष समाज की ले न सका, उल्टे हरी बांधने को चला, जो था असाध्य साधने चला। जब नाश मनुज पर छाता है, जब नाश मनुज पर छाता है, पहले विवेक मर जाता है। The context of these 4 lines for the today's session is, I personally feel that if Lord Krishna would have succeeded in that mediation, if Duryodhana had a wisdom to accept the proposal in the mediation, the historical course would have been changed and we would have already been a 10 trillion Bharat. So in today's society also, we still have that mentality of Duryodhana and we still have a wisdom of Lord Krishna. On this backdrop, I request to the Honorable Chair to continue with, to take over the session. Thank you so much.
Good afternoon, everybody. I happen to be the chair of this session, and considering that most people are out, we have a slim audience to address. Maybe we can make it a small round table instead. So, quite pleased to be here, and I think the members of the panel have been introduced, or have they already been introduced? I don't have the data.
I have introduced in short.
In short, okay. So I greet everybody who's on the panels. It's pre-lunch, so keep yourselves awake. And it's a Sunday, so
everybody will be awake. They will be eager to go for lunch.
So what we plan to do, or with the informal consensus, is that since we are short on time, pre-lunch, we'll keep our addresses to the minimal, approximately 7 minutes. That's a compromise between 5 and 10 minutes. And hopefully we all can, considering that the members of the bar here, I don't know if they can make the submissions concise, but as a member of the bench, I can tell you I can keep my remarks short. So the theme, everybody knows about it. Shall I just, do you all want to speak from the podium or just here? All right. Okay. So I'll just speak from there. I think this is find it slightly convenient. You'll see everybody better. So thanks to the hosts, to the Bar Association of India for having me here. And in particular, thanks to Rachna Srivastava, senior advocate here, who called up and insisted that I can't say no to chairing this session. I must confess I had a couple of very clear reasons, and I must clarify. As being a good judge, I must clarify what's on my mind. So a couple of reasons to decline I had. One was that it was a Sunday afternoon. That is the only time you can present evidence to your family that you exist. So I can assure you as a judge, it's very difficult, considering that we are working most Saturdays as well. And The second was that the topic had 15 words in it. Today's topic, if you notice it, I counted approximately 15 words in it. And you really get some serious stage fright thinking of where to start. You know, there's so many words in there. You don't know how to stitch your thoughts together. But having said that, I thought I will start at a point which is familiar to me, which is the view from the bench. And I'm making some general remarks. The experts are all there. You see, and taking from what Justice Harishankar said, I think when you speak in India about dispute resolution, you must understand that every day we sit with cases, every day, every single day, we get a list of cases of 70 to 100 matters per day. And I just want to make a very simple point. Well, somewhere in our discussions, this has to be understood. And we start the day by thinking that we've already lost the challenge of justice delivery. Because you know it's not humanly possible for any one judge, two judges to actually give complete justice in all those 170 or 100 matters. And this is the thought process we go through every single day. There are 5 to 6 hours that we conduct court, and it's impossible to give judicial attention to every single matter. So what does one do? One optimizes, one prioritizes, one stretches one's judicial skills to maximize our reach. And I assure you, most of us come with that thought process. And we use all kinds of judicial tools, including nudges and hustling the bar which is before us to say, please keep it concise, we pray to you, there are other people waiting. But you still get up at the end of the day, and this is a point that we judges all talk to each other about. We get up at the end of the day feeling that we have not done enough. Because there are people standing in the court who have just got a date of 3 months or 4 months, and it pains us. I also come from the bar. I have gone so many times having prepared the matter with just a date, with no resolution. And today I'm on the other side. It pains us that I can decide, but I'm not able to decide because there's so much of a volume that we are facing. So the last person standing in the court is still distraught. And that is what Justice Harishankar said, is that whole idea of discussing pendency and is something which we need to reconfigure. We have to reimagine it. And somewhere along what my thoughts are, I have some thoughts on it. But mostly in this, and coming to the topic, there are some rays of light. Especially when parties state that they have resolved their disputes through settlement. It brings joy to us. Not because there'll be one less matter to adjudicate, but also because you see 2 sets of people standing in front of you, happy, resolved, collaborated, and a finality which is attached to it. It's no mean feat. What is being left before us is massive pleadings, compilation of judgments. They all pale into insignificance. All that has been filed, but things have resolved. What has succeeded is collaboration and consent. So therefore, what are we achieving through this? We are achieving justice through resolution, which forms the subtext of what we are discussing today. Having again from the previous panel, I'm currently handling a mixed roster, including motor accidents, which involves compensation claims. The oldest of my matters are a huge bunch from 2013, which is about 13 years old, in appeal. Accidents have happened in 1997, 2000, 26 years back. Still not resolved. There are hordes of them. Even if I accelerate myself to a health crisis, even then I will not be able to manage it, but we are trying. Now, amidst this, when we see discussions of, as Dr. Pujari said, dedicated commercial courts, the concern from the bench's side is, what do we do? Whom do we pluck out as a judge from one of these rosters and put them to dedicated commercial or dedicated IP? We have 2 IP divisions, courts. I mean, we have a very strong IP court. And that conundrum, which is usually at the level of the Chief Justice of the court, is a difficult thing to resolve, and none of us can give that solution. So what is important from our perspective is that, again, as Justice Harishankar said, that what comes before us, we optimize, resolve, take the assistance of the bar, and try and finish the matter as well as we can. Recently, the Honorable Chief Justice of India said in a litigation conference, which appealed to me, is that mediation represents the moral evolution of a justice system from technical adjudication to empathetic problem solving. So just underline the word problem solving here, and that's the theme that I would resonate with. It is not an alternative to adjudication, but it's a constitutional value in itself. Let's use that as an anchor. And now we are now tasked with that anchor to reimagine the ADR system. There are 2 principal legislations in place. Sorry if I sound like a teacher sometimes, I get into that mold. But just let's have a sketch. The Arbitration Act, which 1996, which has gone through some significant mutations, and some are around the corner, and the Mediation Act, which is yet to operationalize. So this is the legislative framework. We already have that. There's nothing to reimagine there except as it evolves. Then comes the institutional structures. You have the legislation, then comes the institutional structures. While mediation is handled by the court, by court-annexed mediations, the Delhi High Court Mediation Center is extremely successful. It's a lovely, successful model. We had an international conference of commercial court judges from all over the world recently. I was part of it. And they were amazed that a lawyer-driven mediation center is so successful. They didn't have those kind of models, and there were about 160 countries who have commercial, the judges were there. And so we were very proud of that. And arbitration is largely ad hoc, and mostly ad hoc, and partly institutional. India now has an India International Arbitration Center, which it has floated, which replaces the ICADR. The Arbitration Council is yet to come, and the Mediation Council, I believe, is also yet to operationalize. So what is the next step? You have the legislative framework, you have a pending institutional framework. This is right down from what you are saying in your topic. But how do we go ahead? How do we move from a binary system of adversarial lists, which is what we inherited from common law, to an ADR ecosystem which is more modern in its nature? That is the thought process we must have. And the word is ecosystem. It's not 1, 2, 3 institutions, but a whole ecosystem which needs to be reimagined. And more importantly, one of the other themes that I would throw at the panel today is about hybrid models. MEDAB, ARB-MEDAB, becoming more and more successful in situations like the Singapore Arbitration Center and the Singapore Mediation Center. It's like what I call the SIAC, SIMC tango. The whole modulation, but the way they work together in the dispute resolution clauses that you have, now you get arbitration prefaced by a mediation, and it goes back and forth. You resolve some disputes, you have 10 disputes, you resolve 7 by mediation, that becomes part of an award, and the rest of the 2. So it's a hybrid model. I think we need to reimagine and work on that hybrid model in every institution that is working with dispute resolution. That's one simple message I want to put on. The next top has to be of capacity building, professionalism. A lot of youngsters are here. Train them. Train them as ADR professionals, mediators, arbitrators, give accreditation, continuing education, remuneration, recognition. So many lawyers who are actually spending time being mediators in the evening before the Delhi High Court Mediation and Conciliation Test Center, in their interactions have told us that they are happy, that they are contributing to this process. So some incentive has to be there, a psychological incentive, a financial incentive. For a lot of you youngsters, some youngsters have come to us and say, sir, shall we take interns who say, shall we take mediation as a specialized subject? Ms. Raidu in the earlier session mentioned that she found the gap there in specialized subjects. I'm not so sure about the data because I am not visible to it, but I'm sure students know. But I'm sure there are such specialized subjects. The point is, are you incentivized to take them up? Are you incentivized to take up a mediation arbitration course? And that question has been asked to me as a guide, and I've said, well, you have arbitration, you want to learn it in college, so very good, but you will ultimately end up learning it in practice. So that specialization has to come in law colleges, professional institutions, law firm. The next point I want to come to is institutional credibility, which forms again part of your topic. What do we need to have? These are just words, but each of them means something. We need to have transparency, modernization, neutrality, procedural rigor, quality of decision making, domain expertise, and strict timelines. We have a problem of slippage in India, culturally. We don't penalize for not adhering to timelines. We don't impose costs in litigation for frivolous litigation. Every day in my bench, I threaten people. I said, I'll put costs on you, but I know if I give costs, it'll go and appeal, and a more benevolent division bench will probably say, well, waive the cost. We are not imposing a cost structure. We are not disincentivizing useless litigation. So, where should we, and narrowing judicial intervention. When a user comes and shops for an arbitration center, it's looking for all these aspects. That user will choose because it's by consent. So any link in this whole system is going to erode its viability. And next point I come to is of a more softer nature, that we have to develop a resolution culture. A resolution culture. We are introduced ourselves from the bench perspective. We tell so many people, why don't you go and resolve them? Sometimes actually threaten them to say that I'll dismiss it if you don't resolve it. Somewhere in our mind we realize that possibly we are hustling a bit too much. But in our experience, and my limited experience at the bench, sometimes I've sent two parties outside. I said, please come back at 2:30 and please come back with a resolution. And 70 to 80% they come back because they know the judge is going to get mad. So we are using all kinds of techniques in order to resolve because we can't manage disposal beyond a point. Amartya Sen had placed an argument that niti is not necessarily nyaya. Institutional justice is not necessarily realized justice. Litigants sometimes do not live to realize the fruits of the outcome. So therefore the culture shift is what I'm talking about. The culture shift from skills, learning soft skills of negotiation, collaboration, restorative justice than retributive justice. I know all these are words, but the theme is we need to also be proud of developing these soft skills at every level, advocacy level, judicial level. We need to develop that. I think that is somewhere is required. There's a word called dispute avoidance in your topic. I don't know what it would mean, except that in the commercial world, you have to train people to draft contracts which would provide multi-tier dispute resolution systems so that you don't precipitate a dispute from escalating. Internationally, there are lots of systems like dispute resolution boards and infrastructure contracts. We have it. We have neutral evaluations, early stage mediations. There are loads of tools available. So I don't think we need to, I think we leave it to the panel to. So what I would like to say, what is the mission? The mission is to problem solve. There is a litigant, there is a person in misery, there's a person in dispute. If you're looking at resolution, the mission has to be solve that problem, not burden the whole system. That ought to be the mission of everybody. No one solution is going to fit. Hybrid models will be required and an aggressive cultural shift. So all I want to say is that justice, from my perspective, again a limited perspective, I've been on the bench for a short while, but I feel it's not an edict set in stone, but I strongly believe it's like a plasticine, which you can, as kids we used to mold a plasticine. So it's like a plasticine that you can mold, and which we should all, that should inform our efforts and our discussions today. And I'll leave it to the panel to take up the points further. Thank you. Thank you so much.
Thank you so much, sir. I request Naganand sir to have presentation.
Good afternoon to all the hungry participants. Our human rights have been violated. We have not been able to go and have a cup of coffee or tea. And the 10 minutes which I thought I will have is now curtailed to about 5 minutes or 6 minutes. But nevertheless, seeing such an enthusiastic audience and such an erudite chairman who so succinctly put the viewpoint from a judge. In fact, I often wondered what judges would feel at the end of the day. It was very nice to hear him say how concerned they are and how let down they feel when they find that there are cases which need to be heard but not able to be heard. In the previous session also, Justice Harishankar made a very telling comment about cases which are before the court. So this session is to get out of court. What can we do to be outside the court? Is there a solution or is there no solution? Now, mediation, arbitration, these are two tools, alternate dispute resolution tools. Now, the entire conference is themed on what is it that we can do to get India to the destination of, whatever trillion, I don't remember how many trillion, that trillion economy. How do we get it there? And what can we do about it? As lawyers, as administrators, as judges, is there something we can do about it? It's a question. I prepared a number of slides, but I think out of the 22 slides, I'm going to skip the 15 slides and go down to the 15th slide. Because the earlier slides deal with the mechanism that is there, the law that was there, the changes that have brought about, and the problems with the litigation system that we have had. So till there, it was kind of an analysis of the law. But I don't think I need to analyze it to such a informed audience about how the 1940 Act was there, before that the 1800 something was there, and what happened thereafter, and the 1996 UNCITRAL model enactment, and the subsequent amendments that came about because of the problems that were faced as we went along. But the question is, I'm an investor coming in from somewhere. I'm a businessman in India who wants to invest 1,000 crores on some project. How confident am I that if I have a problem, will I be able to resolve it? If so, how am I going to resolve it? Now, as draftsmen of many contracts, we all put in a clause there to say if there's any disputes or differences that arise, we'll go for mediation. And if that doesn't work, there'll be a time frame. Now, chief executives will meet, and if that doesn't work, then we go to arbitration. Then who is the arbitrator? There are a whole host of litigation, right up to the 7-judge bench in Patel Industries case, which dealt with what is the role of a person who appoints an arbitrator. The law is drafted in such a way that it is a fertile field for lawyers. No, I think the legislators are lawyer-friendly because they make laws which enable us to go on fighting every single principle. Whether that order is an administrative order, whether it's a judicial order, appeal can be filed, 226 will apply. It goes on and on and on like this. So the thing is, the absence of a proper legislation, I would say, is the key factor which would disrupt a business person from coming into India for arbitration. Even Indians who are here also, they will also be asking, many times the clients ask us, well, we are planning to invest 1,000 crores. What is the possibility that somebody will stall it? And is there anything that we can do? So given all this, let's hope we have an arbitral tribunal and it is set up and it is going to do something. then who are the people who appear before it? This slide will give you an idea. We don't have a specialized bar. Most arbitrators sit in the evening, 5 o'clock. You know, we have a full day in court. I'm standing on my feet till 4:30. Sometimes the judge stretches it to 5:15. And the arbitration is at 5 o'clock. I excuse myself, come running here. And I have not prepared anything. And I don't have physical rest. And I continue my arbitration and I blabber something which I could have done with well preparation in 5 minutes. I'll take 15 minutes. The judge also knows it. He says, you have just come from court. No, please sit down, have a cup of tea. Then we'll start. No, this is the kind of arbitration that is going on. I think Mr. Thakkar is also going to say something about it. So this is one thing which we need to address. Address is, let's look at ourselves. How many of us can say, today I have arbitration, starts at 10:30, I'm not going to go to court. I'm going to excuse myself from court. I'm going to return the brief that is there on that day. Will we do that? That's the most important thing to do. Second aspect is, med-ar. I'm presently in the course of an arbitration where it's at the fag end, and we've decided that we'll have a mediation. We had 2 rounds of mediation. Looks like it's going to come to an end. There's some little pushing and pulling going on. Why is it that lawyers think that mediation is not a good solution? I mean, we need to introspect. You know, mediation is not free. You can charge your client whatever fee you have to charge. If recently I was involved in a mediation settlement, about 10,000 crore dispute, about 25-30 cases were there, 2 groups was there, a bank was there, Honorable Justice Ravindran was the mediator. It stretched on for 6 to 8 months, and at the end of it, it resolved. It took off nearly 100 cases from the system, and the company is now back in full action. They've got rid of all this litigation. The banks got their money, the new investor came in, he invested money. Everything happened, and this was a case where there were, as I said, number of cases that were there in various courts. So mediation is not something which is lawyer unfriendly. Let's be clear about it. And in that case, the mediator got paid, the lawyers got paid. So there's really no issue at all. So we need to encourage our clients to be in that mode. So there are a number of things which, I'm not going to take you all through that because of constraint of time. Now there are so many things. How did arbitration travel? Okay. There's the institutional reform, the legislative reform, then judicial maturity, and now the last thing is the global alignment. How are you going to align? I think Vikramjit has vast more experience on international arbitrations than me, and so I leave it to him to say something about it. But what I'm saying is, unless you build world-class institutions in India, you're never going to have a good infrastructure, ecosystem, arbitral system in India. So the thing is, Bar Association of India, thanks to our president and the wonderful contacts that we have built with Law Asia, BRICS and others, we are now at the cusp of formation of a separate foundation for the purpose of setting up an arbitral institution in Delhi, an institutional arbitration, about which my friend Mr. Thakkar will also say a few things. It's an institution where we are hoping that we'll get all the intra-BRICS arbitrations coming into it. BRICS, you know, now it's BRICS Plus also that has come in. So we have a physical infrastructure there and the legal infrastructure, and everything is going to be provided. Now, what needs to be done? There are so many things to be done, we don't know where to start. First, we need to build an institution. Then to build that institution, you need physical and other infrastructure. Then you need an ecosystem where the judiciary will cooperate with it. Of course, now the thinking is that they will not interfere, but nevertheless, Article 226 is something which is looming large, which any order that the arbitral tribunal makes, is it amenable to judicial review under 227, is a question that has often come up. Now, to set up an arbitral institution, there is an enforcement gap that is what is presenting itself to us. Suppose you set up the institution, you get more people to come, the disputes come there, a resolution is made, then what happens to the enforcement mechanism which we have in India? If you make it India-centric, seat is in India, then the Indian law will apply, the curial law will apply. What happens to section 34? I mean, we've been talking about commercial courts, the problem of judges there. I was just arguing a case a few days ago in a commercial court, and I was trying to explain to the judge that this is a case of passing off. He said, which is a section in the Trademarks Act which provides for passing off? Please show me the section. Without seeing that section, I'm not going to grant you any relief. Oh God, then my problem started. Then I had to show him section 27 and tell him 27 is for infringement. It says apart from infringement there can be passing off, and this is the passing off, this is the law. I mean, you know, the thing is, the judges, the judiciary is not, with due respect to honorable judges who have participated and who's here today, I am not making a comment about any individual judge, but as a whole, the system is that they are, completely, what shall I say, all at sea with some new things that happen. So I think, just to conclude, all that I would say is that we need to keep at it. You can't let it go. And if you want India to make progress, not only for outsiders, but for us also, for the Indian businessmen also, how important it is for us to provide a good adjudication system, which is mediation, arbitration, combination of the two. I'll just conclude with a very interesting example that was there. There's a lot of litigation. There's about 20 cases filed in a corporate litigation. It went to, then it was called company law board, went to company law board. Matter was heard ad nauseum. The two brothers were fighting for the stakes in a company. At some stage, the company law board said, why don't you sit down and talk it over? So then mediation started. So they said, we'll go to a mediator. Both sides said, no, Mr. Naganan, you do it. So I sort of acted as a mediator. Then we brought about some resolution of some issues. Then we went back to the tribunal. And then the tribunal said, on this issue we are not able to agree. So the tribunal said, why don't you have an arbitration now? And they said, you be the arbitrator. I said, no, I've been acting as counsel, I can't be. But both of them said, we filed a submission to the court to say, we want him to be the arbitrator, let him decide the figures. So that went through, we arrived at some figures, we placed the figures before the court accepted it and the NCLT and made an order. So that concluded it. So we have to be innovative, Of course, it depends on how parties do it, but these combinations are possible. And it is important for us to bear in mind, these are the various tools that we have. If a surgeon doesn't know which scalpel to use, then he's in trouble. So we must know the scalpels to use, and we must use it effectively. And with the cooperation of the judiciary, it is possible to do it. But we have a long way to go, and I don't know when we're going to reach the end of the road. Thank you very much.
Thank you so much, sir. I request Additional Solicitor General Vikramjit Banerjee, sir, to please express your views.
I think that closes it. Thank you very much for giving me the opportunity to make this presentation, Honorable Justice Dayal, and friends. There are too many people whom I know, so I'm not going to address and acknowledge everyone. I'm just going to sort of maybe sound a little rude when I say things, and I'm going to zip through some of the points of a point-wise sort of presentation. I think our biggest problem, was, as we discussed in all the panels before, is why don't we trust our own system? Is why are our biggest businesses, which are getting into contracts across the world, don't want to have their arbitrations in India? Why are we still preferring the Singapores, the Dubais, the Londons, and increasingly new places to go to, but we don't want to come to India? I think that's the crux of the entire dispute as to what haunts us. And most of them are our companies, most of them are our corporates. And I think there is they will trust maybe the legal system, irrespective of whatever controversies there are in it. But the arbitration system, they seem to be a little skeptical. I think that's something which is the crux of the entire question. Now the question is, the most important part is how do we get institutional credibility for arbitration in India? I think that's the crux which we go over and over again discussing. I think the biggest issue, and I'm going to flag things here which may not be extremely polite, and we all know, but we don't want to speak about it, the elephants in the room, is how do we ensure, the question comes is how do we ensure that our arbitrators are actually free from the influence of their appointing authorities? It's a rude thing to say in polite company when you're invited, when you say these things, but it's a fact. We've all been part of arbitration proceedings. We take it for granted that we find the appointing authority. authority, the arbitrator will be my arbitrator. If he's not my arbitrator, we get like really take it personal and get offended. But how do we ensure that? That's one. The second is, and I think this again is extremely controversial, I'm not casting aspersions on anyone. There is a tendency which I have seen, again, let me be a little rude, is when any system or when any group of people set up an arbitration council or an arbitration forum, at least in India, the tendency is that it starts, and I'm being polite in saying this, it starts revolving around the founders. So it almost becomes a forum for dispensing patronage instead of getting the best people on board. So I think we need to take care of that. I think the government is taking initiative, therefore, to come up with institutions which are much more fairer. And I think unless we have credibility as to those people, I do not think we'll be able to be seen as a viable international center. Third, I think the big issue is how do we ensure actual transparency? And as the Honorable Justice Dayal spoke about, duration is an issue, disposal is an issue. We all know that, of course, it's maybe because we do it part-time, maybe because of very many things, disposal goes on and on and on, number of sittings. And I come from Kolkata, where it's famous for having a huge number of sittings per arbitration, and nothing comes out of it. The fact is also, and again, I'm going to make another controversial statement, and since I'm making it, might as well make all of them. We have appointed, a tendency is in questions of arbitration, we appoint lawyers or judges, mostly judges, retired judges, to positions as arbitrators. We need to get in more experts. So even very complicated, I've been in parts of very complicated engineering disputes where I don't know, I think an engineer would have been better. But when judges are made arbitrators, then you get lawyers to appear before them. That's like, because the lawyers understand judges. While ideally speaking, it should have been engineers, and there should have been experts who were brought in to argue or to put forward their views on arbitration. Maybe the lawyers could have come up for costs or whatever. So as a result, both in the questions of as arbitrators, there are fewer and not that many experts who are brought in. And of course, our infrastructure, the last but not the least, our infrastructure, of course, requires an upgrade. There are not many places which have world-class international level infrastructure. I'm sure we're all working on that. Government's also working on providing that. And my suggestion, and the other aspect is procedural efficiency. I think there has to be speedy dispensation of solutions, time, fix, dispose it off, and not go on indefinitely. Another point which I think we all recognize is that when there is a question of emergency and urgent relief, people still prefer the courts in India. So I will take a Section 9 application and I'll go to the courts. But I will not, in many ways, go to the arbitrator, because once I go to the arbitrator, once there's an interim award, then again it'll come back to the court. So it makes it simpler for me to shortcut it and go to the courts directly and get some sort of an urgent relief from the court, because it's possibly easier to implement. I think our arbitrators should, also start giving interim relief as a matter of course. Another issue which I think, which we all know and which we've all again had reasons to discuss in our private conversations is the awards which the arbitrators are writing. Sometimes, even when they are for, are not of that standard. Because we are busy doing too many things, because we are busy doing too many arbitrations, both for the people who are arguing those cases as well as the arbitrators. Now, number one is because we do it part-time, Number two is also because I think we have too many arbitrations which we handle. I think anywhere across the world, when you take up an arbitration, you just take up that arbitration. You take up one or two matters. You don't take up bulk matters which you do. So therefore, you start doing shortcuts, whereby you adopt shortcuts to ensure that the awards are published on time, and you concentrate on a large number of arbitrations so that your focus is not on those arbitrations. And I think another issue is we don't have the ability, and which we should have, of handling these very complex multi-party disputes, again because there is a lack of expertise, and because we are too involved in the arbitration processes, and because we are largely lawyers. And so we possibly also need to upgrade our skills, which I don't know whether we have time to do, because we are all such busy lawyers, and because all the best arbitration and most complex arbitration moves around some of the best lawyers of the court. So I don't think they have time to sort of upgrade their skills to a level by educating themselves so that where they can deal with these things. And this requires constant education, and it cannot be done off the bat. In questions of mediation, I would, I think the biggest issue with mediation is, I think the Indian corporates, irrespective of what we discuss, should accept mediation as a way of solving their problems. The problem is in their heads. It is not, in litigation or in arbitration, there's some sort of finality, but it seems like mediation is largely used as a delaying tactic. You want to delay the result, let's go for mediation. You want to delay it. While it should be exactly like a way to solve the dispute, which is possibly a better way to solve it. I think the other issue is the courts, as I think Justice Hariharan also remarked, that the courts themselves treat mediation as a halfway house, except for small matters. In large commercial disputes, the courts actually don't prefer mediation. We all know that. In smaller disputes, on matrimonial disputes, on smaller commercial disputes, the court will push us for mediation. But when it comes down to large commercial disputes, irrespective of anything, the courts are themselves a little skeptical of handling all this. But I think the most important thing is, as I said, my first remark is that the general counsels should be themselves convinced that actually it is mediation which can give them some resolution. Now, we see there are two things. In international arbitration, Mr. Naganan indicated to me as if I'm a great expert. I'm not. I don't hold myself as a great expert on anything. But there are two things. I think the GIFT City is a good start. I think if we can get some more things like a GIFT City holding international standards, trying to provide the best infrastructure, I think that's a great idea. And that's a great start. And I think in questions of international arbitration, in questions of arbitrations as such, and this is what I was also just discussing with Honorable Justice Dayal, is that there are, on one hand, there is of course the view in the government that any award should be implemented, that's one, but there is also some sort of a feeling that the government is being ripped off. And that is why the government itself, as we all know, have opted to slowly get out some clauses of below a certain amount. The PSUs there's a move towards getting out of arbitration. And that doesn't, I think, all these legislations were brought in by the government to have a faster, stronger process where the arbitration can proceed. And it's been brought in with great intent, and arbitration was brought in most of the clauses of government contracts. But there is a reluctant reluctant realization that, in that words of Julius Caesar, the fault is in our stars that we are underlings. So there is something which we have to fix. the system is being gamed. So I think that is a feeling, and that only we can fix. So I think there are 2 or 3 things I think we should do to sort of fix. I don't think any problem can be completely fixed, but I think I have 1 or 2 suggestions, and I don't carry a magic wand, and I speak for myself when I say this, not as this entire speech is not as representative of the government, but my experience as a senior advocate having dealt with all these problems. I must preface it so that I'm not held to that Vikramjit Banerjee said these things as in. I think that we have to become ourselves, and this lies within ourselves. I think the biggest issue is not with any process as such, not with any infrastructure as such, but it's up to ourselves as people, as lawyers, to come up to international standards as arbitrators, both as to our fairness, our transparency and skills, as lawyers, as to the way we deal fairly and transparently with the client and following procedure and ensure that the process goes through fast, and also as, in the end, the corporate counsels. I don't know how many of us are here as corporate counsels, but it's, as we all know, as lawyers, as litigating lawyers, it's the influence of trying to game the system doesn't usually come from lawyers as such, though sometimes they're facilitators of it, but it comes from the push from the corporate counsel. So I think they also need to actually realize that a fair, transparent, and good arbitration or a mediation actually solves their problem, and winner doesn't take all. It's not the best all the time. Thank you very much. It's such a pleasure.
Thank you so much, sir. Now I request Mr. Nitin Thakkar, President of the Bombay Bar Association, to express his views. Over to you, sir.
This is Dayal, my co-panelists, friends. We have overshot the time. I don't wish to repeat what my previous speakers have said, but I want to say a few things arising out of my experiences in mediation and arbitration both. I have found that wherever there is a PSU or government in arbitration, that arbitration doesn't end with the award. It is carried right up to the Supreme Court. My suggestion, if for tax matters government can come up with Vivad se Vishwas, why can't government and PSU create some sort of a policy? Their existing policy paper of 2024 is that our arbitration is not successful. Our arbitration clauses in our agreement, our contract doesn't produce the desired result. Why? Because of the no proper advice being given to the government. According to me, government should come up with its own policy whereby they create trust in the arbitration process itself and start accepting the awards which have gone against them unless there is some question of fraud or something like that, which they feel that the tribunal was biased and they have some evidence to prove it. Merely making an allegation doesn't carry the matter further. Justice Dayal mentioned about culture. We must now create this culture. My other co-speakers also mentioned about how the bar should evolve, etc. So ultimately, it is a question of behavior of the lawyers, whether it is in arbitration or in mediation. Why can't we complete the arbitration without seeking aid of 29A? Why can't it be finished in 1 year and 6 months maximum? Because Our lawyers want to ride two horses simultaneously. They want to practice in court. They want to also do arbitrations in the evening. Why can't we have a dedicated arbitration bar? We should be only doing arbitration. There are 2 lawyers in Bombay, there are 3 lawyers in Bombay who are doing exclusively arbitration practice. Why can't we have such a dedicated arbitration bar? We should have that. We should have that culture that what I accept as an arbitration, I will do it. This is Mr. Banerjee mentioned about going to court for the whole day and at 5 o'clock you start arbitration and then you are exhausted, you will do something, you will not complete. I heard from somebody day before yesterday that in one arbitration every day they assemble at 5 o'clock and they for 45 minutes have a cup of tea and discuss about everything under the world and then start arbitration for 15 minutes where they repeat what was argued day before yesterday and now by that time the time is over. So there is no progress in arbitration. Everybody, therefore the clients feel the pinch. They realize that this is arbitration is becoming more expensive than what is happening in court. They don't want to do. There is no professionalism either of the arbitral tribunal or of the lawyers who are appearing in the arbitration. I will give you an example. In 97, I was doing an international arbitration in London. So the 3 arbitral bench, 3 members bench. They assembled, this was 3rd of May, I exactly remember the date. 3rd of May, they assembled, first thing. There will be no coffee break. If anybody feels that he is going to faint, he or she is going to faint, there is a coffee kept in the corner, you can get up, take your cup of coffee and sit, we will not mind, even if you get up in between. 2, one of our arbitrator, his mother has expired day before yesterday. There is going to be a funeral in Scotland on particular date. So on that date we will not assemble. But since we will be losing one day, we will sit half an hour extra on the rest of the days and we will complete the arbitration. 3, every 15 minutes there will be a change of the stenographer and by evening you will get the notes of evidence. In Bombay, in India, my experience was in a day sometimes hardly 10 pages were recorded in evidence. I am talking of 97 where there were still stenographers and typists much in use. On first day in the evening, we received notes of evidence which were running into 67 pages of evidence was recorded on first day. We were expecting this arbitration to go on for 1 month. It was over in 15 days, including the arguments, written submissions, and we didn't have to work half an hour extra because that day was taken as a holiday by the arbitral tribunal because his mother's funeral was there. So this is the professionalism where arbitral tribunal worked. There were, the volume of the matter was running into some 25 volumes. Indian law was applicable. So there was Indian authorities were circulated to them and each one of them had read each and every page. Nothing was required to be read. So this is how we should expect and we should have our arbitral tribunals ready to match international standards. I see that in our arbitrators, they don't read anything. Even section 17 applications, they are not ready with. They would not have read it. So they will make parties read affidavits, everything will be read, everything will be argued, repeated. And this is how everybody feels that this is the retirement benefit. And therefore they are doing these arbitrations. It should not be done that way. Arbitral, unless we create that environment of our arbitral tribunals, that they will professionally dispose of the matters without seeking aid of 29A, we will not be able to have we will not have a competition with Singapore, Dubai and Paris, London. We should have that culture created. So lastly, I want, in mediation, same thing happens. As Mr. Banerjee mentioned, people have mediation only for the purpose of avoiding court, because court has suggested mediation. If we say no in court, the order will not be granted in our favor. Therefore, they go for mediation. I had a under 12A, a pre-suit mediation, a commercial matter, where there is a suit to be filed by an NBFC which could not go to DRT against a company who has borrowed large sums of money. The first meeting they came to me, the defendant tells me, in Marathi I am saying, "Hamala mediation karaycha nahi. We don't want to go for mediation." Why? Tela jaun द्या court मध्ये. Let them go to court. So this is what happened, because he knows in court the decree will not be passed against them for number of years. But then first suit will be filed, summons will be served, they will get time to file written statement. And court doesn't have a time to take up the matter even on a case management purpose. So this is a very sad situation where the culture has to be created even amongst the parties and the lawyers both. Now, I will again give you one more example of my London arbitration. How lawyers ethically behave. The other side made an application for disclosure of some documents on part of our client. My Bombay solicitor was with me. So in a conference we said, why should we disclose? If we don't disclose, what happens? Then the solicitor asked one question, the English solicitor. Is it correct that this particular diaries of which they are asking for disclosure exist? Yes. Since I know about it, we will have to disclose it. You can't withhold any document from the arbitral tribunal or the other side. We have to disclose it. Will Indian lawyers give such an advice to the client? Do we have that courage to give such an advice to client that we will disclose all the documents which are in our possession, whether it is against us or in our favor? We don't do that. This is where we are lacking. So not only our arbitral tribunal should be professional, we should be professional, and ethically we should see to it that we act ethically, morally, correctly. So these are my points. I think I have taken more than 5 minutes. Thank you very much.
Thank you so much, sir. Now I request Dr. Uday Varunjikar, Vice President of Bar Association of India.
Honorable Judge and my fellow speakers, being a last speaker, there are several difficulties. I have prepared my own skeleton. I noted down several points. Slowly I started striking out different points because those are covered by our earlier speakers. And now therefore, I decided now let us start with something extempore, which will be very much useful for the entire, all this galaxy of the legal brains. The speakers contributed a Bombay view, Bangalore view, and the additional Solicitor General also, though there was a disclaimer saying that it is his personal opinion. But let us understand there is one Supreme Court, 25 High Court, around 700 plus district courts, and how many judicial officers are there in the entire country? Around 24,000. Section 11 of the Arbitration Act, who is getting an opportunity? Who are usually appointed as a learned arbitrator. In every bar we find there are DRT lawyers or superannuated lawyers. I am sorry, Judge, DRT lawyers means not Debt Recovery Tribunal, but dismissed, removed or terminated judicial officers. Those
dismissed, removed, or terminated judicial officers are favored as an arbitrator in several places. Let us consider about mediation also. Who are preferred mediator by the honorable judges? Either the judge who has superannuated or anybody who is from this DRT category. Now, if we are having a theme for having a global hub for dispute resolution, then the problem lies with the legal education. Let us understand first, the Advocate Act gives power to the authorities to frame legal education rules. Legal education rules were framed in the year 2008. I'll ask a question to myself, whether this kind of a thought is at all considered while framing those rules. The answer will be no. I noted down in the meantime the important provisions of these rules, and you will be surprised, the practice of law which is defined under the rule also mentions that representing in arbitration proceedings or any other ADR approved by the law is treated as a practice of law. Even though it is provided under the rules, the compulsory syllabus which is provided does not include any of these topics which are discussed throughout the day and even yesterday. How many papers are compulsory? 1 to 20 papers are compulsory, which include jurisprudence, law of contract, special contract, and so many lists. Everybody sitting here, they have cleared those particular syllabuses of different universities. There are optional some subjects, and in the optional subject you will find that there is an international trade law which is one of the optional subject, where little entry of this topic which is being discussed yesterday and today, we can trace that. So the first thing first, if we are having an intention to have a global hub for dispute resolution, then we will have to start from making an amendment in the rules itself. The syllabus will be changed, and then automatically, slowly, gradually, the young blood which is going to come in the profession, they will get equipped to deal with this kind of opportunities. Let me share one more example with you. I am also wearing a hat which is known as a vice chairman of the Bar Council of Maharashtra and Goa, which represents around 2,75,000 lawyers spread in 2 states and union territory. What we have done, we have started CLEP, Continuous Legal Education Program. Why? Because we realize that there are very few lawyers who are trained arbitrators or who can become an arbitrator, or very few lawyers are there who wish to become even mediator. The courses which are available as of now are High Court centric courses. But as I said that around 700 plus district courts are there. So therefore, an attempt was made to introduce a course in which the arbitration will be taught, in which the mediation will be taught. And we are happy, thousands of young arbitrators have been trained, they have been accredited, they got their name included in the list which is published by the Honorable High Court, and all those are at district places. Let me tell you, this arbitration, mediation is not only restricted to the High Court only or the Supreme Court. There is enough talent available outside the High Court also who are ready to take part in this $10 trillion economy and other several challenges. भाई गांव से आया हूँ, छोटा बहुत है, 10 billion वगैरह मुझे पता नहीं कितने जीरो रहेंगे. Let me come back. One more important aspect which is included in this theme is dispute avoidance ecosystem. And I must say, with reference to this, as of now, in our Indian legal education system, there is no such topic. Even if the litigant, even if the person becomes a lawyer, even then, there is no such mechanism by virtue of which we are going to appreciate if any such act is done by a lawyer saying that let us avoid litigation. If some lawyer is saying that let us avoid litigation, as of now the litigant changes the lawyer because he feels that isko kuch aata nahi hai. So therefore we will have to start from square number one so that introduce it in the legal education, and then gradually somebody who is sitting on the dais should also appreciate if some lawyer is giving an advice that let us avoid litigation. The third addition is with reference to the institutional dispute resolution, because that is also one more angle of this topic. What we did, let me share with you. We started an advocate academy at Taloja, which is in Mumbai, and the advocate training has started. I am also told that Kerala State Bar Council has also started one more such attempt. And the most important is our own Bar Association of India, which is having our own now campus, and there will be several such training sessions which can be introduced in the near future. Having said about this, let me share with you, Honorable earlier speaker, Advocate Naganand, one of the vice president, made a reference about the future activities of the BAI, which refers about the institutional arbitration which will be among the BRICS countries. I think that is the future. Now it is BRICS plus, we are aware. Now the countries have increased. And most surprising question came in my mind that our neighboring country is now mediating between two countries. Very strange. It has failed, but ultimately we will have to improve and take a lesson from that and say that no, that is not the place. We will have to market ourselves saying that we are having the infrastructure, we are ready to do several such things. Let us come back, it was on the lighter sense. But in the near future, our Bar Association of India will be one of the such venue which can be termed as an institutional center for the purpose of arbitration. 9 minutes are over. Thank you very much. Thank you, sir.
Thank you so much. Now I request Honorable Chair, Honorable Justice there to conclude.
I think you're all reasonably awake. After such invigorating panel speakers, it was excellent actually, and such fantastic points made, and most importantly, very honest and very candid. I think that is the most, spirited things. Even though from the bench we are constrained on making very controversial remarks, the rest are all free to do so. But you're at liberty to do so. But I think what is important, which came from Mr. Naganand, was about alignment with the international system. So if we see that focus, and what came from Mr. Banerjee was distrust, inherent distrust. I think those things are very important. And then the point which has been taken by Mr. Thakkar about our own professionalism and ethics. I think that there's no magic wand to tackle it, except your own internal search process, except your own education, except that you being surrounded by, also by ethical systems, which you can't ignore. So that's a conundrum which is very difficult. We have arbitration, which is, Mr. Banerjee said about, needless to say, they are, possibly biased arbitrators. And that is, how do you rectify that? Either you impose a huge beautiful institutional system in which there's no leeway allowed. That is one solution. You have an absolutely antiseptic institutional system in which there's no leeway. So that, if there's a corruptibility of the human mind, it will be avoided somewhere. And I think what Dr. Uday Prakash said about legal education, I think that's possibly where it needs to start from. At the grassroots, it needs to. I really appreciated a point about district thing, because, sometimes we lose sight of the fact that, when you're sitting in high courts, it's not only that, although Delhi is a smaller state, I mean, places like Karnataka and Maharashtra are larger states. So the concentration cannot be really at the High Court level, but it has to come down to the district level. That's where the situation has to start. Dispute avoidance has to start there. So fantastic points. I thank all the panelists. As the chair, we have, I have really been enlightened on some points, and please keep on crusading, all of you. So thanks, and to the BAI, and thanks to the, do you have any parting comments, or shall we close the session?
Yes, sir, we can close the session.
Any questions? Sorry if anybody has. I mean, such volatile points have been made, so you should.
It will be presumed that you are not hungry.
So if you permit, may I say something? Yes. This session is between the hunger and the delicious lunch. But I believe that your thirst for different perspective has been fulfilled. So if anyone still feel thirsty, the speakers and the chairperson will be available during the lunch. So you can have your questions. Thank you. Yes, sir. Thank you. Thank you so much, sir.
Friends, two important announcements. One, the lunch is served in the oak tree and the open center after this, so you can please join. And secondly, we will have a group session, photography session at the end of the award ceremony today evening. All the participants will stand here and we'll have a group photography. So do not miss that at the end of the day. Yeah, thank you.
Sometime 6 months I sat with Justice Amri. So I was hand-holding local person. So I got so used to the Maharashtrian accent. I find it very affectionate.
सर मैंने तो मेरा स्पीच अबेंडन कर दिया जो लिखा था वो भी
नहीं आप लोग ने अच्छा किया बहुत अच्छा था बिकॉज़ वो मोनोटोन में अगर हो जाता है ना तो देयर इज नो पॉइंट एक्चुअली
फॉरगॉट टू ऐड आई वाइस ही थर्ड मी बिकॉज़
Dear delegates, please pay attention. We are just in 5 minutes commencing this last working session. The topic is very interesting, the manufacturing contract in $10 trillion economy. Within 5 minutes we will be starting session. This will be the last working session. Dear guest, we are now commencing our 6th working session, and our topic is from constitutional morality to commercial good faith, preserving economic value in infrastructure and manufacturing contract. And may I invite our President and Chair, Mr. Prashant Kumar, to the dais. I also call Mr. Subhash Sharma, Advocate, to be on dais. I also call Mr. Professor Dr. Kamlesh P. Joshpuria on the dais. I also call our session rapporteur, Ms. Surabhi Chauhan, on the dais. And dear delegates, I may inform you that one of our speaker, Mr. Asim Prakash, is not available due to his personal exigencies. But in this session, we will be joining by Mr. Sanmit Ahuja and Mr. Sunan Prakash as our industry expert. Can I request Mr. President?
Thank you, Amulya.
Thank you, sir.
It is going to be a challenging session after lunch on Sunday. And so, please make every effort to keep awake. Because the subject is quite dense. Dense in the sense that various strands get interconnected here. And in a way it is closing the strands of discussions we had today and yesterday. So we will be shortly joined by our 2 industry experts you heard yesterday, Mr. Sunan Sharma and Mr. Sanmit Ahuja, whom I requested, so that whatever we have done, how it echoes with them. Because ultimately they are the ones who have a view other than the legal profession as consumers of legal service, and sometimes at the receiving end of all the atrocities we commit in the name of upholding rule of law and dispensing justice by destroying value. So friends, only a couple of things before I give the mic to Subhash ji, whom you know that if Mr. Fali Nariman was the bard always, there is a, in the IP session also, they said that, the first credit starts from whom the composition comes. So, in the background, Subhashji was always setting the composition. And Nariman was playing out the full orchestra or the symphony in the court. So that's why after Mr. Nariman's passing away, it is Subhash who has completed his works, and earlier he used to contribute notes to the composition, and now he had to complete the composition and play it out himself. So now I will request him in a little while to play his full composition on this topic after. So when I was speaking at inauguration, 2 or 3 things got missed out because of constraint of time. And Jaideep Gupta ji also referred to things. So what I was talking about was not about replacement of contract law or that formalization of law after the informal relational system which was there pre-1872 India is the one which should come back. So it is not the argument. The argument is that the contract law, and Jaideep also rightly pointed out because there were recommendations made in last 20 to 30 years by the Law Commission of England also to change. They don't have a statutory law like a contract law, so they have common law, but they have created various fragmented statutes where these elements have been brought out. And also there have been 2 judgments in which it has been spelled out. Because the courts there themselves realize that in today's economy, you just can't go for a simple template of a written contract which spells out all your rights. You have no other rights except the ones written in the contract, reduced in the contract. And if any party fails to fulfill those rights, the other side has a right to claim breach and go for dispute resolution. So, it served its purpose well in a situation when, it's a contract of sale of goods. It's a contract of a trading transaction, even if 2-3 parties are involved in it. Because their obligations could be frozen in time. There, you had all the related concepts of BAI, this thing and all part of common law configuration. So everything was visible. And parties can reduce into contract what is visible. But today's contractual relationships are so complex that where, like, a refinery has been created in Jamnagar. The putting up of that refinery itself was a decade-long process. What Mr. Sharma will later share with you, the locomotive factory in Madhepura in Bihar took 8 years to build. Now, what will be the issues coming up when you sign a contract to build these factories, to erect major infrastructure projects, or even, long-term projects like today we have been talking about LPG supply, Hormuz Strait being closed, and the chain of economic relationships is so complex that no written contract can foresee, envisage, reduce it into terms. So that is where we say that a contract law environment which can deal with uncertainties things which the parties are incapable of capturing when they start an enterprise. Today's enterprises are that complex. So what you can't envisage, you can't reduce into contractual terms. So, but what you end up doing in the current contract law tradition. So the law as it stands means, you say, okay, this thing may happen, may not happen, but let's preserve my right in advance and put it. So what you keep on doing, you keep on creating a contract which is so over-secured that some way or the other, the parties can falter in their obligation. Because you are demanding through contract obligations which you perceive has a remotest chance of being breached, so I should be secure for that. So what happens, you have a very complex contract in which the basis is what? Protection of my rights. And the basis is what? Because I have zero expectation and zero rights under the current contractual framework that as two parties, because you look at it the other way the contract is defined. Contract is a common enterprise. Two people or enterprises or two or three more come together to share the fruits of a common enterprise. So the word is common, an enterprise. Can any common enterprise only happen on the basis of the written word and nothing outside it? A common enterprise of a large economic state demands trust, demands communication, demands adjustment, demands accommodation, demands change, demands parties focus on performance and not on breach. So what we are talking about is bringing good faith standards, which are the global standards today and have come in English law also today, to be governing the contractual environment rather than the very basic concepts of English law, that where there is a harm, there is a remedy. Now, today you can't envisage a harm. And every harm which emerges later on. And the other thing is, I am having a contract. I have further 10 obligations. Contract goes into dispute. My business value, relational value and other things get destroyed. Do I get compensated for that? How to showcase that this chain of harm is centered into my contract as well. Whereas the other party can take it as an opportunity to use litigation as a bargaining tool. Okay, he has to fulfill his obligation in a 2 billion project. I have only a 20 lakh contract. So I can extract 30 lakh, 40 lakh from him by demanding escalation, by threat of litigation, because he will fail in his 10 billion project obligation. So it becomes an opportunistic tool of negotiation and extraction. And that is what causes delay. So what courts are becoming, what arbitration tribunals are becoming? Negotiation platforms for an opportunistic party which wants to alter the bargain. So where is the starting question of a commercial certainty comes? It is the question of dishonesty. What is the opposite of dishonesty? Good faith. That's why the thesis is how good faith is going to govern the contracts, and that's what is done globally, and that is what is required. Now, good faith is already anchored in the Constitution. In certain spheres, Constitution does not say many things, gaps have been filled or whatever judges perceived in sitting in a particular combination thought, they have turned it and invented the term constitutional morality. Okay, it is not there in the Constitution, but this is the morality we think is part of the Constitution, and that's how we declare the law by our notion of constitutional morality. Now, how far they get conflicted, how far they hold the essential values, okay? So, and it gets so interconnected with the personal notions of the judges that constitution becomes fused with the personal biases, notions and this thing of a particular combination of judges or a judge who is driving. Because, you know, we have a pecking order in a bench also. Sometimes benches are formulated where, you know, dissent is very uncommon, and you'll always have a comfortable majority which will say, yes, this is the constitutional morality. So I think these are the questions which have been dealt with in a huge volume and all by the composer and the bard. So Subhash is best placed to talk about this, so I'll request him to give his exposition. It is not just a
Good afternoon, all of you. Before I start, I must be thankful to over 31 brilliant speakers observing their pearls of wisdom in this meticulously crafted session 1 to 5. My big thank you to the President Prashant Kumar for all his toil and hard work in this convention. I have diligently listened and won't echo any of the insight in last 5 sessions, and I've read all the written materials which he has beautifully put, but I will add my own twist from the start. So 99.9% has been spoken, only 1% is left, and that is what I am going to speak. Now the pressing question before you all is, who will operate this complex system? Who are these great individuals? How do we manage at various levels, policy level, governance level, execution level, implementation level? How should lawyers, judges, bureaucrats, policymakers, etc., conduct themselves? Gaps are there, failures are there, deficiencies are there, over-regulations are there, and delays and so plague our whole system. You have, for the last 2 days, we have been doing all this. We are questioning their roles and responsibilities for the future generation to come. We struggle from our own preconceived notions, biases, battling like hunters to find the beast in the jungle of law. But who is this exclusive animal, which Mr. Sharma had said yesterday, within the system? Who's that animal? Who's the beast? It is us. We are both the problem and we are the solution also. Understanding how to handle ourselves is very, very crucial. Let's dive into session 6 with this perspective, and let's talk and focus on the beast within us by bringing pro-efficiency and expanding our inner potential. In simple words, buckle up for great introspection. Friends, countrymen, and great souls, lend me your ears and your heart for a moment. Yesterday, I was bowled out when I heard a remark of two young and humble lawyers from the pure heart. What real issues are focused? The squeeze of conflict of interest, the squeeze of networking, the squeeze of the partiality in the system, and we are booted out. That was not discussed. But why this great topic, a roadmap of $10 trillion economy, when the globe is burning and economies are eroding? But the other puzzle lawyer said, I don't know how many zeros are there in a trillion. This made me think, this made me feel, and this made me reflect. How can I take this human talent or human content to this part of the great vision in this global crisis? Great souls, remember one thing. What lies behind you, your great glories or failures, and what lies before you, your fear, your anxieties, are all tiny matters. What lies within you? You have a limitless potential. If you persistently work, honestly work, and grind, you will become a conscious achiever. And once you become a conscious achiever, you will definitely find your QR code. And that will be your creativity and innovation. However, the two young lawyers overlooked the three profound words. That was good faith, morality, and economic value. These words, the three words, hold your human destiny. They are the foundation and the guardian of trust. The flames of these words have been for ages. Lit the light, lit the path, warm the heart, and reshape the human mind. Now, coming to our president of the Bar Association, he wrote a wonderful paper, The Rhythms of Monsoons to Modern Markets. I will dub it as Wisdoms of Monsoons Vibrating and Resonating in Our Mind and Heart. What you think and what you feel shapes your feeling, attitude, your habits, and your influences in life, in your life, in the society's life, and in the nation's life. Let us now see how it happens. Raise your hands if you have ever felt disconnected, like a mobile signal in a basement, between what you feel and what you think. The answer is yes. You feel disconnected at times, and this creates chaos, confusion, and disorientation within us. Now, with this, let's travel back into time and weave in today's topic into the evolution of our mind and evolution of our heart, showing connections and disconnections roughly in three historical periods, highlighting the area of concerns where it occurred. The first stop, the ancient times, where it is marked by the innocent mind with a pure heart. Masoom man, Shuddh Hirday. There's no ill will. Good faith and morality was one identity thriving. Thinking and feeling was all connected. Zooming back to 5,000 years back, our ancestors, all of you, were planting seeds, domesticated animals, like cows, donkeys, horses, camels. Donkey caravan was the first trade route, and donkeys have served more than 10,000 years to mankind. Around 1000 BC, man invented the wheel. What happened? After he invented the wheel, he went into the Iron Age, where the Roman Empire, the Persian Empire, the Chinese Qin and Han dynasty emerged. Indian civilization was far ahead. It was 3000 BC ahead. And now, what happened? In this, immediately, let's go little front, at 100 BC, a silk route emerged from the China via India towards Rome. So trade, culture, and like for example, religion, like Buddhism, Hinduism, and Sanskrit flourished. So this was a great exchange. Now zooming ahead to the mid-15th century, I'm just jumping ahead. The Silk Route came, and this Silk Route which was there, it collapsed in the 15th century because the Ottoman Empire in Turkey got hold of it and pushed aside the Europeans. And when the Europeans were pushed aside, they found new routes. And when they found new routes, what happened? European and British imperialism came. So they went out for venture. Now switching gear towards the word morality and good faith. It dates back to the Roman law. And it was rooted in, I call, traditional customs and public duty. This was a cornerstone of the Roman contract law and Roman public law. It was a secret ingredient for the recipe of justice and was a divine social glue. This principle survived the Roman Empire, ran into the medieval mercantile law, and then continued influencing the civil and the common law systems throughout the world. Aristotle once said, if you take good faith from the social and trade intercourse, everything will cease to exist. Good faith has so much of strength, you can understand. And I wish to point out here that for centuries together, merchants worldwide turned to arbitration with the pure heart, innocent mind. A justice system born out of trust, morality, and good faith among the traders. Sir William Holsworth, he wrote 14 volumes on English law. Volume 5, page 129 to 139, you must read. It states that merchant justice system laid the foundation for commercial and mercantile law in Europe. And the courts were always presided by faithful merchants. The traders' community always opposed the court dispute mechanism. Now, coming to the second period, the historical period, where man evolution came up. And this is what I call it, the algebra of revolution. So in this algebra of revolution, there were two parts. Part one, the emergence of a diligent mind and a pure heart. Mehnti dimag or shuddh hirday. Both good faith and morality reflected in our thinking, in our feeling, in our action. This was known as the Enlightenment age, and that is 17th and 18th century. Intellectual movements promoted reason, fairness in law, and rule of law. Good faith and morality stabilized the legal system throughout the world. Good faith then tiptoed into the French civil procedure, civil code, the German civil code, the Russian civil code, the Swiss constitution, and even the US commercial code. And what US commercial code mandated is cooperative, active cooperative morality, means to enforce honesty in the contract. It enforces the bargaining spirit and allows the judge to investigate into the subjective mind and intent and behavior of the parties to ensure honesty in fact. No slacking off, no lack of diligence, or no dragging of the feet. If it is there, the judge will hold you there. But this is one side, the algebra of revolution. The other side was, in contrast, the British Empire. It adopted a different approach, a mindset. Opportunistic mind with an empty heart. Means, अवसरवादी मन और खाली हृदय. Here, the thought, the feeling, and what they did was totally disconnected. It was somewhat like, I call it, the great English pirates, Francis Drake and Henry Morgan of the 16th and 17th century. And for them, there was no morality. Everything is all right. In short, यहाँ तक नजर जाती है हमारा ये इलाका है. So India was stumped. Good faith and morality gone. India's golden era ended by the Britishers. It was in the 18th century. India had over 30% of the world GDP, followed by China. The Indian Industrial Commission report of 1990, British, said India was a manufacturing hub, a great agriculture hub, a manufacturing hub, and a shipbuilding nation. But both the policies of the British and the law, what India, they made an importer from exporter. They sowed the seeds of hunger, poverty, and famine. And our total economy was eroded. Nothing was left. Because now you see the British common law system basically opposed always the concept of good faith. And they advocated market individualism over fairness. Thus, in short, the English law had three markers: adversarial ethics, zero obligation for the other party, values on the written word over fairness. So judge's subjective or gut feeling has no value. And the third consideration, the word consideration in the Contract Act of the English law, which we have borrowed, used objective exchange of value as a fairness. Means this allows the judge to police the maths of a deal, but not the good faith or morality of the deal. Dear countrymen, India and 48 nations, which are known as now Commonwealth of Nations, inherited this great British common law system. It lacked the definition of good faith and active cooperative morality. My appeal is to bring the following amendments. Define good faith coherently, bringing in reasonable diligence and reasonable expectations by amending the Contract Act and deleting or remodeling it by the provisions which are inconsistent to the definition of good faith. Second, enact preventive laws to protect and preserve economic values of the property. And also, now simplify and improve upon the arbitration with the trader's mindset, means innocent mind and pure heart, rather than having a judicial one or a courtroom drama. The remedy is what Sir William Holsworth said: merchant justice system presided by faithful merchants, bringing back this old spirit of arbitration. Arbitrators are not to imitate courts. They are there to decide, not to teach. This teaching leads to more confusion, distortion, and lack of clarity. You see section 34, 37, High Court, Supreme Court, and one matter went even to the curative petition, DMRC matter. So, if India wants to become a hub of arbitration, then Indian clients, Indian lawyers, and Indian judges must change their mindset. Nothing can be happening. Now, constitutional morality. Mr. President, I did not use the word constitutional morality, but only morality for the following reasons. Excuse me. The pre and post independence laws and the Constitution has always used the word morality, and nowhere the word constitutional morality is there. The true meaning of morality, constitutional morality was from Grote, Ambedkar, means and applicable to the citizen. This is applicable to the citizen and constitutional functionary to respect, to give reverence to the Constitution. But recently, in last decade, a new amorphous concept of constitutional morality was created through PILs by use of Article 142 of the Constitution and ultimately expanded it to a super basic structure in 2018. And surprisingly, this has even prioritized the fundamental rights in Part 3 of the Constitution and even added and deleted and rewrote articles in 25 and 26, and especially 26(1), where the Constituent Assembly intentionally omitted it, but they added it as if it is there. So this itself is a violation of the basic structure. Of course, all these issues are there before the 9-judge bench about the true identity of constitutional morality, the meaning and the contours. That is for the judges to decide. My short point is the importance of morality in our lives. Sir, first, liberty is what you can do. Morality is what you cannot do or should do. Number one. Number two, both morality and liberty lies within us. And it's very important for our well-being. The opposite of morality is immorality. Now, question is, why morality is essential for the human being? Morality is not just rules or convention. It is inside us, our mind, heart, and soul. It's like the 10 commandments written on our DNA, like the tablets, shining tablets. Stealing, hurting others, violence and crimes are wrong, I can agree. But what happens? They harm you first from inside, then it harms the other. This is a trap in your depths of your own selfishness and ego. So it cuts you off and loses your soul joy. This is the source of all ailments in our life. Now, if you stay truthful, honest, disciplined, compassionate, devoted, peaceful, you will find or get connected into the true freedom of your soul. So morality becomes an essential part of your well-being. Dear countrymen, when morality dies within you, like it did in the decline of the Roman Empire and many other kingdoms and recently many countries, no law, no constitution, no court, no army can save it or revive it. In case there is a change of constitution, morality will survive and remain in us. Where will constitutional morality go? Now stepping into the present third historical step, stopping point. Our internal struggles and fears from our scheming and manipulating mind and empty heart forced us what I call the algebra of transformation. This shift manifests into two distinct transformations, namely a negative transformation and a positive transformation. Dear countrymen, it is time to pledge and judge yourself. Are you aligned with the negative transformation, or are you aligned with the positive? Or in the morning you are aligned with the negative and in the evening you are with the positive. It's up to you. Then question is, who are we? Now I'm taking first negative transformation. Negative transformation signifies a selfish mind and an impure heart. Now we have transformed from opportunistic to this selfish mind and impure heart. Swarthi man, oh, Ashuddh Hriday. Thus creating disharmony of our thoughts, feelings. In a sense, what it creates is a big ego, small mind, and narrow heart. I don't know, you may be feeling the present life. After World War I, II, the global landscape has marred by greed, selfishness, hatred, intolerance, ego, and aggressiveness. Throughout the world, if you see, we have witnessed the deschooling of humanity through two troubling behaviors. The first, the superpowers, the supermen, the super corporations of technology, and now the rise of the quantum AI, artificial intelligence, replacing and controlling human beings and killing their creativity and critical thinking. All this are engaged in endless violence and vicious wars for power, for profits, and for dominance on the earth. While the great international institutions are helplessly watching on the sidelines. It may lead to a nuclear warfare and the total annihilation of the earth. Enough is enough. Dear compassionate and chosen one, President Donald Trump, the whole world is one big home and you can save it. Peace be unto you. Now second, many of us suffer from the Shakespeare, I call it, Hamlet complex. And that is the inability to decide or to commit to anything. We want to be fair to all sides, this side and that side, whatever benefits we can get, oh, take it. But we remain in our comfortable zone. We don't want to take a stand for a cause. The silence is questionable, avoiding responsibility. Dear friends, here most of us are stuck between the violence and silence, and one day it will bury you in between. When we harbor this type of mindsets, then who is responsible? God? No. The question is, please raise your hand. It is we. We are responsible. As Shakespeare said, the fault, dear Brutus, is not in the stars. It is in ourselves that we are underlings. We must take responsibility and ownership and offer no excuses. Then you will get a chance to become a better man or a woman in future. Now coming to the second part, positive transformation. Maybe, some may be there. It is cultivating a compassionate mind and a devoted heart. Dyalu man sampar hriday. A human approach. Live your life. Embrace your limitless potential within you and align yourself with the inherent qualities of a human being. And that is peace, love, compassion, joy, devotion, leading to higher vibrations of life. This will definitely foster harmony, unity, and oneness with everyone in this universe. So let us get rid of the old selfish crusader type low mentality of killing each other attitude. That energy should go, because it's because of our past glories or failures or future anxieties or fears, we are getting stuck to it. In short, as the outdated global system of the 20th century has crumbled and are not working because of our attitudes between violence and silence. So this new dimension of positive transformation will create a human setu, or I can call a bridge, an internal unity and proficiency and oneness with the others to overcome the present day problems of mankind. This bridge, human bridge, understanding will be much bigger than any super infrastructure or super manufacturing projects. So we can easily surpass 10, not 10, but $100 trillion. Mr. President, Prashant Kumar, you profoundly said we have to distribute prosperity and not poverty. Well done. So let's call and build a new global system and responsibilities rooted in compassion and devotion before it becomes too late to save this earth. Now coming to third point, how to preserve the economic value in these times. Sir, value has three dimensions. Three dimensions. The first is the economic dimension, second is the functional dimension, and the third is the emotional dimension. First, economic dimension is the monetary worth of a good or services to an individual. Consider China, take first India, consider India as a service sector. Fantastic for 2 decades. Yet mainly the large companies benefited. But the human being with the common talent did not get the same benefits. Take China, manufacturing hub, great manufacturing hub. Everybody participated. The human talent flourished and the entire nation benefited. One village is preparing one type of shoes, the other one, right one, left foot, this. So everybody is busy and they projected it. This is the economic value. Now coming to the second dimension, the functional value. This involves technology, innovation, research and development, a crucial aspect which requires long-term investment and long-term patience. For example, I can give you USA and China best. They had long-term investment and long-term patience, and see how they have developed. This is the functional value. Take Steve Jobs. When he saw BlackBerry, he made it to iPhones. It was a long-term investment for me, and it's so easy for you people to enjoy that. The guy is gone. So we have talent in India. We have talent in India. But sadly, there is lack of investment. Sadly, there is lack of investment. This mindset has to change. We must invest in it because it requires long time patience. And we don't have that patience. India has the right ecosystem to build. Our Prime Minister, Narendra Modi's vision to make in India is marvelous. The infrastructure and the manufacturing sector are two sides of the same coin. Infrastructure has done wonderfully in the last decade. So now comes to the third dimension, that is the emotional dimension. Dear countrymen, competency and skill can be bought or outsourced. But human values steeped in trust, morality, good faith are priceless. These fundamental drive the progress of an individual and of the nation alike. India has been the land of dharmas and shastras. Indian mind is intellectual, artistic, but we are also very spiritual and ethical. India has the highest number of youth in the world. My appeal is to invest in this human talent. Let us make brand Bharat a global hub for human talent. A global hub for human talent. Let India lead the world and become great again. Finally, dear great souls, I see the limitless potential within you. Within you also, sir. But I don't know what it is. I don't know what it is. You have to find. You have to find. You have to find your QR code by changing your mindset and projection. We are not just in the universe is within us. It's like the ocean in a drop of water. We are all one and connected. Don't think we are not one and connected. This is now scientifically proven by the quantum-informed non-universal, by the Nobel laureates from 1933, 1972, 2022, 2025, quantum entanglement and quantum tunneling. It's all proved. What our sages of the Sanatan Dharma said that thousands of years ago. So, service to humanity is our true religion, with a compassionate mind and a devoted heart. So make brand Bharat a global hub for human talent and invest in it. Make India a great golden bird of this planet. So good thoughts, good words, good deeds will guide us. God bless you all with good health, clear blue skies to fly, and success. Jai Guru, Jai Bharat. Thank you.
He has written about Guru-Shishya relationship. See, one very key takeaway is, and that is what Bar Association is trying to launch a project also. As you know, constitutional morality is when you are propounding, you are bringing a nation under a constitution. That constitution has to pervade the consciousness of people and has to become a part of their common morality. Because India is a country with different religions, different faiths, hundreds of sects, different regions, languages, customs. So once the constitution came, it became the common morality connecting the whole nation. Now this has been appropriated by the court to mean something else under Article 142. So something which was for the citizens to assimilate became a judicial interpretative tool. So how far that is right or wrong is a separate thing. It is not a discussion today, but it is good to make this distinction. The other aspect is the key theme, that no sustainable systems, whether commercial, societal, or systems of administration of justice, can exist without the central pillar of good faith. Because good faith is the one which sustains a contractual relationship or societal relationship beyond the written code of conduct, terms of contract, because human behavior, how the world operates, what kind of uncertainties or circumstances will arise, nobody can capture, because that is the design of the divine. So you cannot divine the terms of a contract to envisage things which you cannot conceive at the moment you are writing those terms. So that's why good faith. And when we talk about common law, please understand, in commercial field, UK is now becoming, it is receding in number in terms of, trillion size economies. And if you look at other economies, each one of the major economies has this central pillar of good faith. Because the law which is not common law has been crystallized and accumulated in the form of unid right, which is called universal law. And unid right is the law which is practiced, adopted, cited in most of the international disputes which are not based on Indian contract law or some elements of English law. As I said, even English law has transformed. So that's how, and one last comment on the historic Roman law. See, Venice, when Sharma said about the Silk Route, Venice was the center of trade. The first merchant courts emerged there. The concept of a limited stock company got created there. Why? Because one ship will carry goods of so many merchants. And sometimes, like in today also, you can split the container when you are importing. So a ship will carry goods of many merchants. And those kind of ships with the mast and this, and not the modern kind of ships, there was always the risk in the sea expedition. So to share and distribute risks, each expedition became limited by the shares of each merchant. That's how the concept of limited stock company emerged. But then Venice was ruled by a doge. They had a feudalistic system, and the merchants there became part of the network, and it became so restrictive that they did not allow new capital or new traders to come. So because of that restriction, ultimately Venice lost its sheen and value as a trade center. The trade center shifted not merely because of Ottoman Empire interceding with the naval fleet, but also because of this monopolization or cartelization. And it went to the Dutch. But rightly or wrongly, Britishers have been the best people to look for an opportunity and how to capitalize. So how from Venice to Dutch it came to England? It came through the marriage between the British court and the Dutch royal family. So through the marriage, they did not even have a relationship between the two royal branches. They took everything as if it was a dowry to England, and it is England and English common law which came into force. This is the historic grid. But this also tells a story that the power to write the rules, to make the law, is where the economic value gets created, which becomes the center of economic value. And today, if Asia, if India, if other emerging economies are becoming, then why the legal systems are not going to slowly migrate to protect the interests, to protect the priorities, to create an environment conducive to interest of such economies. So this has been the history, and I think the flow of history remains in a way that power flows where the power centers. Law is the one which regulates and mediates it. So we have completed a dialogue on good faith, the centrality of good faith. So I will just ask Kamleshji to give his views, and after that, we are expecting Mr. Sunand Sharma also. Then how Sanmit looks at it from the point of view of India attracting technology, investment and all. And especially, he is dealing with the European Union right now.
Honorable and esteemed Chair, Sri Prashant Kumar ji, other honorable and esteemed fellow panelists, and equally honorable and esteemed dear colleague, I am coming from Rajkot, which is the capital city of erstwhile Saurashtra state. Prashant Kumar ji just visited Rajkot on our request to inaugurate one national level seminar organized by Legal Research Foundation along with Mumbai Center for International Arbitration on ADR. In a lighter vein, I would like to share some information about the Rajkot. Rajkot is well known for siesta, and of course I am not a part and parcel of that system, but there is one joke that even the beggars used to keep the signboard, do not donate the coins, only notes, because if you are giving them the coins, it will disturb the beggars. So it is compulsory between 1 to 4 to donate through currency notes only. So, and even otherwise, dear friend, Rajkot is well known for their eveningers. Evening newspapers are very much popular in Rajkot, across the Gujarat, not only Gujarat, the Western India. So, of course, it is always very difficult to speak after the delicious lunch. Friends, in fact, in Sanskrit, there is a famous quote, Vade Vade Jayate Tattvajnana. Prashant Kumar ji, शास्त्रार्थ के माध्यम से ही तत्वज्ञान प्राप्त होता है. वादे वादे जायते तत्वज्ञान. I was listening Prashant Kumarji in yesterday's inaugural session. Friend, I would like to share a very interesting information about his lecture which took place in Rajkot. Prashant Kumarji has floated the idea of uncertainty about the Indian situation, and very next day the local newspapers have captured that particular idea about the doctrine of uncertainty. So, I must compliment Mr. Prashant Kumar, President Sir, for his classical approach about the Indian economy. I would like to express my sincere gratitude to Prashant Kumarji for giving me the opportunity to express my views. My congratulations to Prashant Kumarji, Amarjit Singh Chandok ji, Amarjit Singh Bedi ji, Anandita ji, and entire team. And of course, I must mention the name of Mr. Subodh also, and entire ground team who is taking care for all of us, dear friends. Really. Friend, in fact, it's my firm belief that our collective vision is to transform India into the Vishwaguru. 10 trillion economy means what? In future, India will be a powerful economy. At the same time, India will become the Vishwaguru. So at a very important time of Amrit Kal, we are organizing this very important seminar. I do not consider the outcome of the seminar as the proceedings, but it's my firm conviction that outcome will be the historic Delhi Declaration of Rule of Law Convention 2026, dear friends. As Sarmaji rightly pointed out about our great nation, about our glorious past, about our position as Vishwaguru, sharply deviating from, of course, I fully subscribe his views. Dear friend, in fact, why I am telling you sharply deviating from his views? No doubt that we are having that kind of glorious past with us. Oldest civilization of the globe, there is no doubt about it. But the nation like India, we will have to evaluate impartially about our present position, and at the same time, we will have to work out the future strategy also. No doubt, powerful political leadership always essential for the overall development of the nation. There is no doubt about it. But legal mechanism, legal background, sound legal position always plays a vital role in overall development of the nation. Friend, in fact, with the permission of the chair, I would like to discuss about the current constitutional dimension and new regime of definition of the state. Article 12. What it is? First time pragmatic judicial announcement came in the year of 1967. That's a Rajasthan Electricity Board case, then Som Prakash, and then up to Board of Cricket Control India, Board of Cricket Control Board of India. That was in 2005. All the time, the Apex Court has taken the pragmatic approach about the interpretation of Article 12. One of the research paper is on Article 12 and its interpretation in the broader perspective of public enterprises. So I quote one of the sentence. Look at the reality of the ground. Most infrastructure and manufacturing projects today run on unorganized sector labor, contract workers, daily workers, etc. When we enters into any kind of contract with the government, or contractor enters into any kind of contract with the government, or government enters into any kind of contract with the private players, this was my hypothesis. Yet when a project gets terminated or a contract is breached, the first casualty is this very workforce. Payment stop, job vanishes overnight, and family suffers, all because our contract law sees only two parties. This was my hypothesis, and of course, other way, I intend to assess it through an alternative lens. In particular, we must reflect upon the very beginning of our Constitution, which opens with the words, "We the people of India." This signifies that the ultimate authority rests with the people. It is for this reason that we often use the popular expression Janata Janardan, meaning that the people are revered as a manifestation of the divine. The Indian Constitution is founded upon this very philosophy. Therefore, whenever we deliberate upon constitutional morality, ethics and moral values, whether in the context of public sector undertaking, multinational corporations or public-private partnership models, it is essential to remember that such arrangement involves agreements between the government and private entities. However, there is a pressing need to adopt what may be termed as the third way thinking. The central idea of my today's lecture is about the third way thinking. Suppose on one hand government is there. Either it may be a PPP mode, public-private partnership. Either it may be a PSU. Either it may be a multinationals company. Either it may be a big contractors. What is the meaning of third way approach? When on one hand government will be there, on other hand any contractor, PSUs or any other entities may be there. But traditionally, according to the present Contract Act, it will be binding to two parties only. Contract always take place between the two parties. I have completed 6 minutes, 4 minutes to be there. I am very much aware because watch is with me. 4 minutes only, I am just concluding. Honorable Sir is very much with us, so I can understand. The third way thinking, government should keep in mind that ultimately money comes from the public, money comes from the taxes. Ultimately, it's a public money. So in third way thinking, I think government will have to think about the people also. That's a kind of third way thinking approach. Nowadays, it is gaining momentum. Apart from the basic concept of Hindu economics, I think there is one very good book by a Mr. M.G. Bokhare on Hindu economics, and the third way thinking by Mr. Dattopant Thengdi. Both the books are very much relevant in the present context. So my only submission is about the third way thinking approach government should adopt. Thank you very much. Namaskar. Vande Matram. I have completed my lecture in 9 minutes, so you must compliment for me.
We always compliment you. You come with the perspective of an academic and now of a practitioner.
Sir.
Thank you, Dr. Saab. Sanmit, so now when we are looking at India-EU FTA, where it is not just the text of the free trade agreement, but all other issues which are also important. And you are interfacing directly with the stakeholders in EU and Nordic countries and others. So, in your experience, what we have been discussing here about making good faith and relational contracting and protecting the long-term value in contracts to be an approach to go forward. How do you look at it from the point of view of FTA really materializing in kind of investments, in kind of economic relationship we are looking at?
Thank you, Prashant. I'll ask people an anecdote, real anecdote. Those of you who are young parents, or those who are not even, how many, raise your hand if you'd seen the movie Finding Nemo? Right? And so those who didn't, it's a movie about a fish. A child fish gets lost in the ocean, and the father fish starts searching for the child fish, and somebody tells that, I think we saw the child fish in Sydney. Right? And they told, how do I get to Sydney? Sydney's so far away. And then the person said, or the fish person said, there's a big stream of fish moving at a very fast pace, and the other fish says, somehow get onto this stream and get off exit number 37 and you'll reach Sydney in a matter of 45 minutes or an hour. And lo and behold, the father fish reached Sydney very, very quickly. Otherwise, it would have taken them years to get there. The moral of the story is global economics offers us these jet streams. And if we don't climb into these jet streams, we'll just see them, the economic opportunity pass away. Right? That's the moral of the story. So how does it manifest in the context of the various free trade agreements, not just EU-India, but various free trade agreements that India is signing with other countries? Some of it is geopolitical. Thanks to a certain president, there is chaos that's being created, and people like certainty, people like balanced trade and economic relationships, so it's pushing those people towards us. Others are joining because they're seeing India rising on the totem pole, so now we're the fourth largest economy. And then there are those who are still standing on the sidelines and waiting for things to happen. I'll be as bold and provocative in saying that signing free trade agreements and getting the signature on the dotted line, frankly, means nothing. Right? Yes, it does establish trust, establish a notional bridge. So essentially what free trade agreement says, if we were importing European wine and there was 100% custom duty applied to it, now that custom duty kind of goes away, so the wine doesn't cost 20 euros, it costs 10 euros equivalent. Doesn't mean India will become a nation of wine drinkers tomorrow. The creation of the market still takes very long time. So we need to first find touch points which are beneficiary to both, and that's where technology becomes a very central pillar. If we have to become Viksit Bharat by 2047, I coined a term which eventually got used by the government. We have to make technology accessible, affordable, available. Right? These are three key terms and have a slight nuance difference. So technology accessibility, what does that mean? Our growth will depend on utilities, electricity, clean electricity, water, waste management, road construction, port construction. All of these areas need technologies. If I go to Germany, if I go to France, if I go to Norway and try and bring those technologies into India, and we've been doing so for the last 15 years, the first point, and this would be much interest to the legal fraternity, was the perception of leakage or theft of intellectual property. The first barrier. Right? No amount of assurances will convince the other party that your IP is safe. Right? So we as a nation firstly have to stand up and give that assurance, not verbally, but put those institutional structures, give a legal protection that your IP is safe. India is now a signatory to TRIPS, but again, that's a multilateral, multinational organization. How does IP protection translate on the ground is very, very critical. So what have we done about it? We said, let's bring our institution of eminence, the IITs, the NITs, the Indian Institutes of Science, other institutions, to come in as a collective, work with every government department, whether it's Ministry of Power, Ministry of Energy, Ministry of Agriculture, to give a joint confidence to the counterparty that your IP will be safe. So this gives me IP accessibility. Right? Step number 2. Somehow I convince Europeans to come to India. The technology is dead on arrival at price points. Right? So if I'm buying a compressor, if I'm buying a biofuel manufacturing solution, the price points that those technologies prevail under are under European economic conditions. Give you an example, the cost of wholesale solar power in India is about 2 rupees 50 paisa kilowatt hour. That's the money, that's the amount that the grid gives you when you bid for a tender. And you have to earn 15% margin in that 2 rupees 50 paisa. Same thing in Europe is 10 rupees equivalent. So their grid gives them 10 rupee equivalent. So the same solar power in Europe is 10 rupees, same solar power in India is 2.5 rupees. So they worry, well, how are we going to make money in India? Just not possible. Why should I bother? Any answers? Thank you. The market size. So I give them an answer that the largest solar power producers or owners, not producers, owners of solar power in India are foreign private equity funds. Right? Because you're giving orders of 100 megawatts and multiples in one go, you're able to procure the input materials at a much lower price. Your cost of money comes down. Your cost of operations comes down. So if you don't think scale, and scale does not come naturally to European countries. So a lot of them, if you go to Eastern Europe, they're very, very afraid, not afraid of the size of the market. They countries which are as small as 1 million, 2 million people, they just get worried that this market will just eat us alive. We don't know where to start. So India has to step up and make affordability not just a word, but we have to translate step by step how will you make that solution affordable through scale. How? First step, make in India. And that's what, when I talked about IP, the fear of IP getting lost became very real. So make in India. So we said, okay, don't worry, now that you have the IITs and the government with you, we are ready to open up the market, provided you make in India. So before COVID, we convinced about 5 or 7 companies. Today, we are over touching 80 technologies that we brought in from Europe and Nordic countries, right? And this number will double in the next 6 months, because we perfected the process of Make in India. We have 2,000 original equipment manufacturers on our network across the manufacturing clusters of Hyderabad, Coimbatore, Pune, Gurgaon, Ahmedabad, so various manufacturing clusters around the country. So if I need to bring an engine in and unbox that engine, where do I get the nuts and bolts? Where do I get the wires? Where do I get the pumps, the washers, the pressure, whatever the different components are? What would take a company 3 years, we now do it in 3 weeks. Right? But all using the strength of our national institutions. Right? So that's step 1 of the affordability. Step 2 of the affordability is cost of money. Right? The cost of money for a project in India, if you're Tata, you'll get money at 7.5%. Government of India borrows at 7.5%. So if you're Tata, you'll get money at 9%. If you're a SME, sadly, the money is not available for you for under 14, 15%. That's way too expensive. Denmark offers money at 3%. Switzerland offers money at 3% in their currencies, not in rupee terms. So we then looked at how do I safeguard that capital investment? Can I borrow overseas and deploy capital in India? Foreign exchange volatility is an issue. We're working with RBI to design a framework, but that framework will be ready. So that's the affordability aspect of the solution. The final point is availability. That how do I downstream? Now, I've brought the technology in, it's made in India, we get access to capital, but I still need to take it down to the masses. And unless I take it down to the masses, what's the point of doing all of this? So we're designing now a training program for engineering contractors. So with each technology, the engineering contractors, so if you were, for instance, if you're buying Microsoft, there's Microsoft Gold Partner Program, where Microsoft trains you and gives you the tools. So we are training and giving people the tools to disseminate this technology across the country, right? And working with state governments, length and breadth of the country, to saying, how do I fast track this solution? And the model framework is called First of a Kind project. Because first of a kind, so if I go to various municipalities and state governments, the first question is, Berlin में चल रही है वो मत बताओ, Bangalore में चल रही है नहीं वो बताओ. Right? Now everybody wants to be the first to go second. But who puts the first one then? So sadly our institutions are caught up, our bureaucrats are not incentivized, rather they're disincentivized, because should the technology not work, the bureaucrat will be skewered on their file, right? And they're extremely afraid of signing the first one. So again, we went back to the government and said, we need to create a program, and the government accepted. It was Minister Gadkari ji who said, go for it. So if IITs and others are involved, institutions are involved, then the government does not mind giving capital for the first one. And trust me, the technology works. It's never the issue with the technology. It's everything around the technology that doesn't work. Give you an example of biogas. Why is biogas such an old solution? Why are we not firing all cylinders on biogas? Why? Because the feedstock, the waste that needs to come in, never comes on time, never comes on quality. It's highly, highly disorganized market. So the tech works, the ecosystem around it. So the first of a kinds address the ecosystem. And the final point, so we started doing that, and we have about 15 first of a kinds already established. I showed you examples of the satellite first of a kind yesterday, but happy to share more details. Final point on how will we climb that jet stream. So we said, if this, we've done the hard work of bringing the tech, we've done the hard work of making it affordable, we've done the hard work of making it available, how do I make this opportunity make a $10 trillion opportunity? And that's where the global markets open up for us. So the real strength of India is not just doing what we do within the country, is to help accelerate the entire global south, all emerging markets, to say, look, we've done it in India, we've made the technology affordable, now we're making it available to you as well. So we launched a program called the Global South Technology Acceleration Consortium. So 37 countries have signed up already to that. Earlier this week I was in Bhutan, so first of those was Bhutan, and we signed up biogas, bioenergy, data centers, hydropower, and all these technologies we've brought from around the world. Because if they start to do this, they'll face exactly the same problem: IP, cost of technology, cost of capital. So over the last 10, 15 years, we've traveled that journey and built that trust and built that confidence and built that platform, that the gateway, India becomes a gateway of global technologies to the global south. Right? And that's really how you get to a 10 trillion economy. Thank you.
So Sanmit has given a wonderful map, but just see how complex it is. how interconnected various relationships are. So you have European technology creators, you have international funds, you have IITs and other institutions here, you have Government of India here, you have private enterprises here, you have chain of suppliers located in different parts of India for the supply chain. Now just look at it, the web of contracts it requires. Every single relationship is to be put under a contract. And if these contracts continue to be rights, obligation, breach, remedy centric, how do we do it? Because one break in the chain breaks the entire chain. In one dispute, value locked destroys the value across the chain. It is just one small component maker finding an opportunity to default, okay, this is too big, I am supplying this, I can wrangle more value, let me create a dispute. And then maybe I can coerce, blackmail, or, using dispute resolution as an arena, not just of contest, but a selfish, opportunistic bargain. That is where the centrality of good faith comes. That's why I called Sanmit to tell you how a complex web of economic relationships is supposed to work for us to make this journey, like finding Nemo. So now we have Sunan Sharma ji to round off, to say that how in terms of big projects and all, unless until this good faith and this relational environment is not there in contracting and its enforcement, apart from what lies there in Mussoorie, the jungles of Mussoorie. So let's see the jungles of where the courts and the dispute resolution centers exist.
Thank you, Prashantji. My apologies to the audience for being a bit late. However, between yesterday, the 8 hours spent here, and the absolute richness of discussion which has taken place in this room, from no less a person than the Honorable Chief Justice of India to all the luminaries who have presented their variety of ideas, I actually had a bit of a sleepless night thinking through, where is the solution? We talk of the problem, but could there be a solution? And then on the way here, something came across my mind which the legal fraternity, working with the government, working with the entrepreneurs, can actually structure. I pose it like this. Prashantji, can it not be that we invent a structure suitable for India? I'll explain. I discovered that about 20 years ago in Australia, where they had similar laws, similar colonial overhang, similar issues to ours, both in legal and in financial and governmental processes. Can it not be that we are able to carve a new structure for development of intellectual property of all kinds? In the creation, I'll use loose terms, the legal fraternity can correct me, a special project vehicle to be created, which is ring-fenced, which actually, in the words of Sanmit, I'll borrow from what he was ending with, actually, in an interesting way, rewards failure rather than punishing it. Because in a laboratory, unless you have experimented and you've gone through a series of failures and tests, you cannot succeed. That's proven over history. It's a fact. So here we have perhaps a construct of a legally protected special purpose vehicle which is detached from all the normal routine governmental authorities and yet managed with transparency, with a structure which has government and private sector and institutions involved. Let me build on that to the next level. Today we have, under allocation of Business Rules 1961, we have a division of work across the entire ministries. Ministry of Heavy Industry, Science and Technology, MEITY, and there's an alphabet soup of ministries over there. They have inherited over time extremely great institutions, starting with things like the Council for Scientific Industrial Research, the Defense Research Institutions, the civilian research institutions, everything from space all the way down to, I will use the actual term, even down to gobar gas. Now, all these are in silos. They are in silos, and the people don't actually talk to each other. They don't. Ministry of Heavy Industry, for example, has repository of information it doesn't share with the Ministry of Defense, which is producing military tanks in Avadi, in Chennai, where the actual knowledge of engines may be residing in heavy industry and the requirement may be in defense, and there is actually not a proper conversation going on. So, ring fence, create an architecture where, borrowing from the true meaning of public-private partnership, where you say that risk capital of the kind required by the special purpose vehicle, and Sanmit, you'd agree with me that there's long-term capital. I mean, today we've got longest of long-term capital building a bullet train in tens of thousands of crores. We don't need tens of thousands of crores. We need a reasonable sum of money to create that jump start and make sure that that vehicle, yeah.
Just one point on that. It's not that tens of thousands of crores are available, we are not able to tap it. So GOI has been smart and assertive and confident enough that we signed a free trade agreement with what are called EFTA nations, EFTA. So EFTA stands for European Free Trade Association, which is 4 countries, Norway and Iceland on the western side of Europe, and Switzerland and Liechtenstein on the eastern side of Europe. Now, Norway, as most of you would know, has the largest sovereign wealth fund in the world, 2 trillion under management. That's just one entity. So when we signed the free trade agreement, there's a mandatory requirement for the EFTA nations to invest $100 billion in India over the next decade.
Okay.
Mandatory requirement.
Okay, I'm better educated now. But let me finally complete that structure. Now imagine this. And this is a real-time example I'll give you. BHEL has technology, metallurgy, software, and source codes for design of gas turbines. Similar metallurgy, similar source codes, similar materials are needed for the fighter jet engine industry. I can assure you from personal knowledge, they don't speak to each other. It's a national asset. And if you can actually take the repository of that metallurgical data, that heat transfer technology, that knowledge, put it all into a certain structure. And I can't think of CSIR as that structure because that'll get lost. I'm suggesting a new one. Meaning this structure, allow it to, if they have failure, allow them to fail. Because you cannot succeed without that. And borrowing from the Australian example of how they created a methodology of such leverage which was breathtaking. They had to build the Sydney Harbour Tunnel. And they had to have a structure on the basis of which they could have the money to do it, and they didn't have the money to do it. Legal and financial minds, and there's an actual chair on this subject in the University of New South Wales, which I know of. The professor was a friend of mine. And you would find that for a minimal amount, you could do all of the developmental activity. That means the acquisition of land, the permitting, the licensing, everything you needed, and then reach a point that the contract structures, Prashantji, are so well done that they finally become bankable. Ergo, you have proven something in a special purpose vehicle at a lower cost than the total risk of taking it in the subsumed overall cost, putting the entire structure to risk. You don't put the entire structure to risk. You risk only the beginning end. The moment that all conditions precedent are met, all the risk falls away, and risk is then assumed by the user. The user could be the Navy, the user could be the Air Force, the user could be a government department, the user could be anybody. It could be somebody in the private sector who wishes to acquire the technology. I mean, the US actually, those of you who know about it, the entire structure of all the major companies in technology came out of an original program called DARPA, D-A-R-P-A, Defense Advanced Research Program, created in the 1950s. We have no such equivalence in our environment, and the legal brains of the USA structured it in such a way. For example, they would give the money upfront to a Boeing and a Lockheed and say, both of you build an aeroplane till the time you have succeeded, and we will have a fly-off, and the person who actually meets all the staff requirements is the winner. Now, the other one who was making the losing plane didn't lose money. He actually received all the money he needed to develop his style of aircraft. That is the structure on which the gigantic industry of aviation came up in the USA. I think I've communicated what I wish to on this. There's a tremendous amount can be done. If you need to get to 10 trillion, I personally believe, and I'm not exaggerating, if you put a value on the intellectual property held by the departments of the various ministries of India put together, I will not at all be surprised if it exceeds $10 trillion if you went to market it.
It is not just the value locked in the disputes, it is not having legal instruments to unlock that value is equally important. So I think this dialogue and this intersection between economics, policy, industry and law is something which is a missing gap. This is the missing link. This is the highway or the jet stream. If a jet stream has to be made, law has to be part of it. And without that, no journey can be completed. That's why we take enormous satisfaction that this endeavor by the Bar Association of India could start a conversation between Niti Aayog and the head of the judiciary and the Prime Minister's Economic Advisory Council, and informally, while waiting for the Chief Justice, both the luminaries and the Attorney General, we were all together in the room discussing certain issues, and that informal discussion itself was so illuminating and gap-filling in terms of knowledge and institutional understanding across the board. So I think we have to structure it further, continue it, take it forward, and what has been discussed, find the ways how to implement it. And we are so fortunate that our honorary chairman is nobody else than the Attorney General himself. He is that link which the Bar Association of India has, which can structure these relationships, and we will stand behind him as an institution to support this national mission. So with this, I think Sanmet just wants to say something.
No, so my both submission and commitment, Prashant, to Bar Association for inviting us here, and from our side I can commit that we will give you the framework for each of those nodes on the jet stream, and if with the use of help and contribution from this august gathering, we can design the construct, which is a multi-stakeholder, multidisciplinary construct. I think we've put in the guardrails for the jet stream.
Thank you. And just to end, 2 weeks back, I was in National Stock Exchange having a dialogue on climate finance. And Sanmet had organized it. And when they learned how, because I call now Bar Association of India as a think tank, as a legal think tank. So how, a bar association or legal sector can contribute to it. So they found it quite illuminating, and they also find that these are the things they have been trying very hard to find answers to or solutions for. So I think across the board, we have to structure these relationships, move forward. We are a great nation. We have a great capacity. Just to say that India has a potential which is never achieved, let us break those walls which make those potential unachievable. That potential is lying locked. It is in our vaults, in our intellectual vaults, in our mental capacity within us. Let's unlock it. And let law be one of the keys. Thank you very much.
I thanks all the panelists, especially Mr. Sunand Sharma and Mr. Sumit Sharma, who have to, we request them to come and speak at the last session, last working session. And with this, we are ending this last working session. And we will be straight away commencing the last closing ceremony.
Yes. So we'll have a photograph?
Yes.
Photograph first. Not that photograph. Okay.
We will start the closing ceremony immediately because Honorable Chairman of the Law Commission of India is just on the way. Our other honorable guest, he has come. So we will start immediately. We'll just change the arrangement. And we are thankful to Law Commission of India also for providing two excellent rapporteurs who are the consultants with Law Commission of India, because we want this bridge of information and exchange to be institutionalized. So we will be collaborating more with the Law Commission and see how we continue to strengthen these bridges. ये तो कह रहे हैं आगे। ये ठीक है। सुबोध, ये हैबिटेट वाले कोई नहीं आते मदद करने के लिए?
उसको चाय डालने के लिए भेज दिया ना सर, अभी गेस्ट
किसने भेजा?
पीछे बैठे हैं ना चीफ गेस्ट।
अच्छा।
I welcome the chief guest for today, Honorable Justice Dinesh Maheshwari, Chairperson, Law Commission of India. Our guest of honor, Attorney General for India, Mr. R. Venkatramani, and other dignitaries, President Prashant Kumar ji, Rachna Srivastava, our Vice President, Dr. Anandita Pujari, Vice President, and Mr. Saurabh Mishra, Joint Secretary, BAI. This is the most important session, both from two perspectives. It is not only the closing session of the convention we had for 2 days, but also because we are giving awards to the awardees of Lawyers of India Day. But before that, may I now request Mr. C. Madan Gopal ji to give a bouquet to our chief guest, Justice Dinesh Maheshwari ji. May I now request Bibhu Tripathi ji to give a bouquet to our Attorney General as a token of respect and regard for. May I also now request Shrijit Chaudhary ji to give a special bouquet to our President, Bar Association of India, Mr. Prashant Kumar.
We should not be giving bouquets to ourselves.
This one deserves it.
This is for the Bar Association of India team. All the office bearers, cumulatively.
And now may I request Ms. Rachna Srivastava, Vice President BAI, to give her introductory remarks.
Very good afternoon to you all. Honorable Justice Dinesh Maheshwari, former Judge, Supreme Court of India and Chairperson of the Law Commission of India, Shri R. Venkatramani, Attorney General for India, Mr. Prashant Kumar, President, BAI, Dr. Anandita Pujari, Vice President, Mr. Yakesh Anand, not here, Vice President, Shri Saurabh Mishra, where is he? Amarjeet, General Secretary, Ms. Rija Chaudhary, Advocate on the dais, distinguished awardees of the Lawyers of India Award, members of the Executive Committee, members of the Governing Council, participants from different parts of the country. At the end of the 2 days of a very stimulating and brainstorming sessions, we are here to mark the closing ceremony of this important conference on legal reforms, roadmap to $10 trillion Bharat. Over the course of our deliberations, we have engaged in thoughtful, rigorous, and forward-looking discussions that have reinforced a fundamental truth that the journey toward economic transformation is inseparable from the strength, efficiency, and adaptability of our legal system. As India aspires to become $10 million economy, the role of law cannot remain static. Law must not merely react to change, it must anticipate, facilitate, and shape it. The conventions we have had over past sessions have made it abundantly clear that legal reform is not a peripheral requirement. It is central pillar of national progress. We began this conference with a shared understanding that India stands at a pivotal moment in its economic and institutional evolution. With rapid advancement in technology, growing global integration, and increasing complexity in commercial transactions, the demands of our legal framework have multiplied. The question before us was not whether reform is needed, but how it must be structured, prioritized, and implemented to support sustained and inclusive growth. What has emerged from our discussions is a rich tapestry of ideas and actionable insights. One of the key themes that resonated throughout was the need for efficiency and timeliness in the justice delivery system. Delays in dispute resolution not only affect litigants but also have a direct bearing on investor confidence and economic activity. A robust mechanism for speedy resolution of commercial disputes and adoption of technology-driven processes were highlighted as essential steps in this direction. Equally significant has been the emphasis on the simplification and modernization of laws. Rationalization of outdated laws, reduction of compliance burdens, and clarity in regulatory frameworks are necessary to create an environment that fosters innovation and entrepreneurship. Legal certainty and predictability are indispensable for economic growth, and our reforms must aim to provide precisely that. Another critical aspect discussed at length was the intersection of law and technology. From digital evidence to artificial intelligence, from data protection to cybersecurity, the legal landscape is being reshaped by technological advancements. The need to equip our institutions, both judicial and administrative, with the tools and training to handle these changes cannot be overstated. Technology must be embraced not only as a subject of regulation, but also as a means to enhance access to justice and administrative efficiency. We have also reflected deeply on the importance of institutional capacity building. Legal reform is not merely about changing statutes. It is about strengthening the institutions that interpret and enforce them. This includes investment in judicial infrastructure, continuous training for legal professionals, and fostering a culture of accountability and transparency. A strong institutional framework ensures that reforms translate from paper to practice. Another dimension that has found prominence in our deliberation is the role of collaboration. The path of $10 trillion economy cannot be charted by any one stakeholder in isolation. It requires coordinated efforts among the legislature, judiciary, executive, industry, and civil society. This conference itself stands as a testament to the power of dialogue and collective thinking. The exchange of perspectives across disciplines enriches our understanding and leads to more holistic solutions. What we have achieved here is not the end, but a beginning. As India strengthens its position on the world stage, our legal system must align with international best practices while retaining its unique character and responsiveness to domestic needs. A balanced approach will enable us to attract global investment while safeguarding national interest. In closing, I would like to express my sincere gratitude to all the speakers, panelists, organizers, and participants who have contributed to the success of this conference. Your insights, expertise, and dedication have made these deliberations meaningful and impactful. The diversity of viewpoints have been particularly enriching and has reinforced the idea that legal reform is a shared responsibility. Let us leave this forum with a renewal sense of purpose and a collective commitment to action. The vision of $10 trillion Bharat is ambitious, but it is within our reach if we align our legal frameworks with our development aspirations. The law must serve as both a shield and a catalyst, protecting rights while enabling growth. I am confident that the ideas generated here will serve as a strong foundation for the reforms that lie ahead. Today, we also recognize the outstanding contribution to the legal profession of 5 luminaries, namely Shri Aditya Sondi, Senior Advocate, Mr. Mohan Katarki, Senior Advocate, Shri H.C. Upadhyay, Advocate, Ms. Preeti Suri, Advocate, Professor Rajiv Khurana, Professor of Law, University of Delhi, Rajiv Khanna, Professor of Law, University of Delhi, and honor them with the Lawyers of India Award which were announced on the occasion of Lawyers of India Day, which we celebrate on the birth anniversary of our first President of India, Dr. Rajendra Prasad. Thank you very much.
Thank you, Ratnaji. May I now request our President, Mr. Prashant Kumar, to give his address.
Chief Guest, Chairman of Law Commission of India, Justice Dinesh Maheshwari ji, our very own Honorary Chairman of the Bar Association of India and Attorney General for India, Shri Venkat Ramani ji, my dear and esteemed colleagues, both on the dais and off the dais, and all the other dignitaries, guests and delegates. I think you have already heard me ad nauseum, so I will not be speaking longer. We have very important part of this convention which is remaining, that is the Lawyers of India Day Awards, which will be conferred today. And we have the luminaries of legal profession, doyens of academy present here, whom the Bar Association of India is doing a favor to itself by recognizing them, because it is only through the richness, both in profession and in academia, which they have created and contributed, that empowers the institutions like bar or the bench. That's how the legal profession and the administration of justice moves forward. Friends, I am very happy that this convention has partly served its purpose, that we were able to break silos and open dialogues between policy, judiciary, and legal fraternity, as well as industry and investment. So this conversation itself has a meaning, value, and significance by itself. And if we are able to take forward these dialogues in terms of actual implementation, I think we have justified our endeavor. And I'm very happy that both the Chief Justice, the Vice Chairman of the Niti Aayog, the Prime Minister's Economic Advisory Council's Chair, our own Attorney General, and now we have Law Commission, the last and the main and the most significant pillar, which has the mandate to present the legal reform reports to the government, being part of this conversation, of this dialogue. So it is fitting that the closing ceremony, our chief guest is the Chairman of Law Commission of India, because the issue of good faith and relational contract, which we discussed, was there in 199th report of the Law Commission of India already. It was not acted upon, but Law Commission of India has made an endeavor, and now I think when we have, like in the movie Dhurandhar, they say that when the right time comes, things will happen, we have to wait. So we have that right time where the attention of the government and all the institutions are how to make India more prosperous. As I said, that one of the themes which has emerged, because we are calling it rule of law, then how talking about economic prosperity and $10 trillion is connected with the rule of law, because rule of law resides in justice, And justice is also social and economic justice, distributive justice, equality. But at the end of the day, we cannot distribute poverty. We have to distribute prosperity to give rule of law its real meaning. With these words, I think it is now with the Attorney General, because we want to hear from him how he looks at it, this endeavor, and with what vision he wants to promote this further. Thank you.
I think I must bend down a little. Probably can this be removed. Okay, that's fine. Respected Justice Maheshwari. Well, Prashant wants all of us to be King Midas. All that we touch should become turned gold. Right? But then, in order that happens, there's also a problem. Before we touch everything and turn gold, we must know how much to touch and when to withdraw from touching. So that's, I think, the connection between law, economics, and governance. So when Law Commission is here, I think it will tell us how to be careful and how adventurous we can be about this touching business. So that's why it's an important confluence of thoughts with the chairman of the Law Commission being here. Now I feel that at one level of speed at the global confluence of thoughts, migrations of people, resources, ideas, and capital, we seem to be somewhere at some point and not a point of reckoning. That's why we keep on talking about what we need to do. I think if you speak as a historian, there are quite a good number of reasons why we figure where we are today. But we can't be mere historians of the past. We need to be writing our future. So how to write our future? So that needs, like yesterday, how to imagine brave new worlds where the shackles which we had owned for a long time can be just given up. So all this exercise is about entering into very intense debates on where we have not looked closely the developments in global understanding of ideas and their migration, their reception, and after all, ultimately, what drives any one of us to a sense of fulfillment. I think every individual would like to be at home and they say that my imagination, my creativity, my innovation, my ability, being so facilitated by the so-called development economics and all that. So the innovation and creativity element which each one of us possess, and we employ them in different walks of life, it generates wealth and value for the community. I think economics, the study of economics, is all about that. So how do we therefore generate wealth, value, that in every individual in our community and society feels part of that? And when we don't do it by way of a structured process, then there is a community and a social wastage. And economics also study that. Therefore, when you are calling upon ourselves to have a deep and intense relook at a variety of laws and our legal framework, more particularly the justice delivery system, it's important that we keep on thinking about it, and conferences, particularly valedictory functions, are not merely the closing of our engagements. They just remind us that we are closing for the day, but keep our minds open for the rest of the year. And we keep meeting as often as possible, collectively, individually, and keep our minds engaged on these important concerns. And so I'm glad to be here today. I've been just talking to Prashant for a period of time on some of these ideas and how to go about structuring them. I suppose with the Law Commission being here, we give a framework of suggestion to the Law Commission. After all, Law Commission need not necessarily go by recommendations from or references from the Government of India. I suppose today we live in a suo moto world, right? I suppose so. The chairman of the Law Commission will feel so encouraged by being here and will encourage us becoming a little more suo moto, where the discussions in the conference can probably keep your table a little more expansive and ask from us whatever we can be a part of an engagement and what I call certain fundamental legal reforms in which a connection between law and economics. Just to close my remarks, and our law schools I find very well equipped and senior counsel here, and I know they're products of the National Law School in different parts of the country. But over a period of time, I find the way law schools have produced legal knowledge has lagged a little behind what I may call structural changes in our understanding of law and justice and the economy. So if structural change is required, it's not merely some clinical knowledge, some practical knowledge about what do you do in courts, what do you do transaction, practice, is something beyond that. So I always remember when Professor Mann used to tell me legal education must become justice education. I think he was a prophet, and not merely justice in the sense delivering justice through our adversarial system. Justice in a sense what community probably is looking for, that each and every individual will feel rewarded in every walk of life they're able to engage themselves in. And that's important structural change which legal education must bring in, and that's why the collaboration between legal education and justice delivery systems, governance, and I think must meet. And I'm sure if on this subject, the Law Commission can have a deliberation, and certainly I can command all the law schools to come together and other institutions which are partly engaged in the delivery system to be part of a, just telling Prashant that we probably conceive of a standing conference on law, economics, and governance, which not necessarily left to governance. It can be in the hands of private initiatives also. So that's where Bar Council, Bar Association of India, and other bar associations of right thinking people should come in and join hands for a glorious march of a brave new world where India can lead, as they always say, not hegemonically, but by way of sharing. So after all, the only spiritual tradition we had about sharing all our knowledge, ideas, and understanding. So I suppose we have a wonderful time yesterday and today, and I personally pledge myself to whatever Bar Association of India would call on me. I'm sure each one of us would pledge in the same way, and I'm sure probably before we meet very soon, we would have had some kind of a thought process which would have urged upon governance to look at it very seriously. Bar Association of India must and deserve to be taken seriously. On that note, I conclude my thought.
Thank you, Attorney General Ji. Before I call our chief guest, I fondly remember on 15th April 2023, chief guest Justice Dinesh Maheshwari was the chief guest then also, and we spoke about, the session started with discussing about the fruit mango, and that sweetness I think still continues. So with that note, may I request our chief guest to please give his inaugural address.
A very good evening to all. In fact, during my college days also, there were used to be some such wonderful teachers. Whenever you meet them, whether in classroom or outside, they would, apart from giving us a lot of, chocolates and a lot of things to relish, we would always be left with some classwork to do and some homework to carry home. So, learned Attorney General, sir, the most respected and revered of all present here, has well done his part here again. My teacher, as he is, given me classwork as well as homework, before with all of you being the witness, and I humbly accept that, and I'm very sure all of us together would be putting our heads down, collecting ourselves together, and make sure as to what is the idea and intent behind these classworks and homeworks. And Attorney General Sir, President Sir, Prashant Ji, the dignitaries on the dais, and senior advocates, the other legal luminaries, professors, dear students, ladies, gentlemen. It's indeed a matter of not only privilege but responsibility too when I stand here before you in this concluding session of Rule of Law Convention, so thoughtfully conceived, structured and organized by the Bar Association. I'm very sure, and as I've been told by my legal consultants too, who had been the part of some of the sessions here, that deep-rooted, meaningful discussions have taken place, are going to go a long way in redefining some of our thought processes and ensuring that are marching to ensure that India, that is Bharat, regains its rightful place, the glorious place in the global order. We are already on the road to that. Legal reforms roadmap to a particular quantum is stated in terms of dollars, and I'm very sure the days are not far when even those quantums will be stated in Indian currency, that is India, that is Bharat. That is what we aspire to, that is what we would be doing. India, that is Bharat, and whatever we discuss about our future plans, our roadmaps, I'm always having an impulse to share a few lines and a few thoughts from our roots, our glorious past, which are always with us and which always keep on reminding us as to what we are. And I'm not saying what we were, because there are certain things which are permanent about India, that is Bharat, which I would always proclaim is not the name of a nation only, it's the name of a civilization, it's the name of a civilization that has sustained itself, that has prospered, that has progressed from thousands of years. There are certain fundamental factors why we as civilization have been able to sustain anything of challenges, as to why Swami Vivekananda in 1893 was able to say, proudly proclaim, that I come from a nation of the principles of values of universal toleration. We believe all religions as true, We have given shelters to the persecuted of other places. From Swami Vivekananda to another gentleman who chose for some other reasons to go over the fence and to the other side of the fence, and who was a votary for the partition of this great land. Yet he would proclaim, and we do remember those lines always, when he said, यूनानो मिश्रो रोमा सब मिट गए जहाँ से, कुछ बात है कि हस्ती मगर मिटती नहीं हमारी, सदियों रहा है दुश्मन दौरे जमा हमारा. Allama Iqbal. Now, it's interesting, and particularly for the younger generation, I would say, to admire that a gentleman who otherwise chose to go to the other side of the fence didn't continue with India, that is Bharat. We have not ever, not even a moment, disrespected him either. And his lines we do recite with a similar respect, no problem. How it happens, why it happens? It happens because there are certain fundamentals which are innate in us. As we, as students of law, we always admire that our constitution is not a mere collection of certain jurisprudential principles alone. It's in fact a projection of certain universal values on which civilization, that is India, has always stood. Justice, liberty, equality is not taught to us by any other jurisdiction. That had been ingrained and innate in us. Whether it is proclaimed in Rigved that there is nobody inferior, nobody superior, no Jesht, no Kanisht, or it is proclaimed in Maha-Upanishad, the last word of that shlok is a motto, a hallmark of various institutions also, I see, and in various of our discussions also, when we proudly say that we belong to the concept and the culture of Vasudhaiva Kutumbakam. Ladies and gentlemen, that Vasudhaiva Kutumbakam comes from chapter 6, verse 71 of Maha-Upanishad, and the complete verse is, Ayam nijah paroveti ganana laghu chetasam udar charitanatu Vasudhaiva Kutumbakam. This is mine and this is yours. Tera mera. This is a concept of narrow-minded people. The broad-minded, the large-hearted, udar charitana tu Vasudhaiva Kutumbakam. That is what had been our ethos, that is what had been our fundamentals. And that had been the reason that whatever had been the challenges, we have dealt with them. We have stood firm as a civilization. Having said that,
I would immediately touch upon the challenges of the current days and make a few points in that regard, particularly as regards integration of technology, if it is posing any challenges, we are capable of dealing with that, and for that matter, the lawyers community is always having an AI at its disposal, or rather as its asset, which had always been of existence much before the advent of AI, which you know today. Our AI is our authentic intelligence, which had been a hallmark of the lawyer community always. We have been, lawyers particularly, they had contributed not only in the freedom struggle, not only in the making of the, our constitution in the Constituent Assembly, but they have been and they are the fundamentals of the trust and faith factor of the society. And that is where society is confident, the confidence of the society lives. A lawyer, and not necessarily an advocate in the court of law alone, a legal professional, a lawyer who has studied law and who continues to study law, has that authentic intelligence with himself that any challenge existing or perceived or potential or looming large or lurking over, he or she is always capable of finding meaningful solutions for that. That being the position, and then when we know that in the present day's global order, you need to evolve commercial good faith too, apart from living by the principles of constitutional morality. The lawyering community is always ready to provide new age solutions. And in that quest, these kind of conferences are going to go a long way, I'm very sure. Evolution of a republic is not measured only by the law it enacts. It's basically, it is measured by the values it upholds, and then its capacity to evolve with the times. That is again hallmark of Indian civilization. We have been evolving with time. If somebody is to look at some offhand examples, the UPI regime which India boasts of, when you are able to find that even a roadside vendor is having, apart from his materials or machines, a machine readily available with him or her, and India as a whole, and in every corner of the country, you are able to do transactions online. it appears simple, but we need to admire ourselves for that matter, that this vast country, the vastness of it has also been well utilized for the purpose of evolving. And we are in a position that accessibility to technology for the purpose of real-time commerce is not away from even the person remotest in the line or remotest in the corner. That is what India is, and that is what India is capable of. That being said, friends, and again, when we remind ourselves that there had been certain, kuch baat hai ki hasti mitti nahi hai hamari, there had been and there are certain fundamentals and certain basics with us. Over the period of time, yes, some of those basics either got deflected or got overshadowed by certain other influences. But all said and done, we are fastly on the trajectory to shun off, to clear off some of those shadows and to regain our position, our status. And that is where comes, when we talk of a legal system particularly, comes our promise of Indianization of Indian legal system. When I talk of Indianization, it's not simply changing the name of an enactment from Indian to Bharatiya. Well, that is needed, that is we have done. What we are on the road is to ensure that if there were certain values which were ingrained in our system and which were fundamentals to our Indian jurisprudence, if they have got somewhere deflected, if we can restore them with, of course, new branding with the present day requirements, we need to do that, and I'm very sure we would be doing it. An example, I'm tempted to present for your thought processes, a food for thought, if I can say so. And I'm very sure you will be able to find much better solutions than what they might appear today. Defamation, gentlemen, ladies. If we look at the fundamentals of the Indian legal system and the Indian jurisprudence, Bharatiya Nyaya Shastra I am talking of, defamation was not conceived to be a civil wrong at all. It was, in the fundamental of the Indian legal system, an action not acceptable by society ever, and it was an offense. Honor of a person, and mind you, our constitutional promises are not merely of those capital letter words of justice, liberty, and equality and fraternity. There is something more fundamental, assuring the dignity of the individual is a part of our preamble. Dignity of the individual, the dignity of the individual it's not that it is, by the way, making a part of our constitutional promise in our preamble. We have placed the dignity of the individual at the highest pedestal. Defamation, not a civil wrong, it's an offense to the society. We have, over the period of times, evolved into, well, taking some instructions from some other jurisdictions, some other jurisprudences, where you may have and you are having a civil suit being filed seeking compensation for this so-called civil wrong of defamation. We need to appreciate in the first place and admire that, well, to start with, in our jurisprudence, we never took it as a civil wrong. It was an offense. A person's dignity, a person's honor was something, and it remains always something which is non-negotiable. We need to rekindle our thoughts into not only this, but all the different spheres, different areas, and contribute our parts in ensuring that when we look for something like simplification or accessibility and technology, the integration of technology being the three main areas where legal reforms are expected and always are attempted at, we make it sure that all our efforts towards reforms have in their fundamentals our understanding that our legal system, our jurisprudence, our substantive laws, as also the laws of procedure, are Indianized in true sense of term. We are very sure that with Indianization, we would be able to ensure rapid progression towards a robust economy, a society that could be giving, leadership to the global world, to the global order. Commercial world, if I talk about, friends, again, we are aware of the capacities of an Indian. When we have in our constitution something of a freedom of settling anywhere in the country, and very many times certain challenges do come up because of that too, but that is all a part of a vast society. We are aware of the fact that this freedom is not utilized only for the purpose of roaming around here or there. We have our commerce people, particularly the business community, migrating from remote corners of one place of the country to farthest other side of the country, and settling down and excelling in business, being accepted dearly and meaningfully contributing to. Friends, I come from the state of Rajasthan, and particularly my native place is my city of Udaipur. I could see some of the delegates here coming from Udaipur too. Well, I was tempted to share that capacity of the business people from remote corners of Udaipur going down south and being accepted as honest, meaningful business people, trust and faith had been fundamental to their entrepreneurship. It's not that they were simply going for some adventure and settling down there. In a different society and different culture, getting yourself settled requires something of the fundamental of you being accepted, you generating faith or trust. And it doesn't stop of movement within the territory of our country alone. We know of and we are proud of our people establishing themselves as, again, meaningful business people, contributing to the economy and, of course, ensuring their own growth too. Wherever they have gone, they have worked. It's not that there is something extraordinary about an Indian, except that an Indian carries with him or her certain fundamentals, certain values which are existing across the board, which are innate in us, which are ingrained in us. And those values are the strength by which we have been able to acquire respectable places all over the globe. Being the position, when we are looking for transformation, progression rather, towards a robust economy, what is needed for us is, in the present context, in the present day requirements, to remain sure of, to remain conscious of our roots, our fundamentals, our values, and thereafter having that confidence that these values, these fundamentals have allowed us to, or have made it possible for us doing things which sometimes are awe-inspiring for the global, or for the world, for the other people. Precision, friends, a hallmark of our value systems. Well, whatever we do with clarity as also with precision. And precision, when Prabhu Ramchandra is being doubted by somebody about his capacity to deal with the enemies and is being asked to demonstrate, is able to ensure that his one shot of arrow pierces through 7 trees in a row. From those stories to the story of Mahabharata, where Arjun will make it sure while killing Jayadratha that his head would fall in the lap of his father only, who had given a boon that anybody who would be making his head to roll on the floor on the ground, the killer's head itself would be blown to pieces. Well, right from the battlefield, the severed head would land in the lap of his father. To the recent day stories of, and not stories rather, happening of something like Operation Sindoor, where we hit the persons who were required to be hit with precision while sitting thousands of kilometers away. We are capable of doing it. We had been doing it. The precision is our hallmark. Our courtrooms are another demonstration of the precision, the clarity. And these discussions about delays or backlogs, friends, they of course cause us concern, but they do not bother us in that sense that, well, as if our system is crumbling down or our system has some such lacuna that, well, it may fail in its goal or it may fail in delivering what it is supposed to deliver. The vastness of the very requirement of legal system we all are aware of. The lawyers, the judges, and for that matter, there is another block of role players who are often not acquiring that attention in our discussions, and that is the support staff, whether the support staff of a lawyer's office or a support staff of a judge's office. The amount of work, the amount of devotion, the amount of contribution they make at the cost of several other conveniences. That is again a hallmark of an Indian. That being the position, friends, we are capable of finding solutions. Yes, there are some such challenges of which we need to put our heads together and find meaningful solutions. Something like excessive delay in dealing with the matters which ought not to, dealing with the matters in the courts of law particularly, and delivery of justice, ensuring, because very many times, well, if you do not ensure delivery of justice in the timely manner, the delay itself, well, defeats everything of the promise of justice. There, it's not only the modulation of our laws of procedure. Of course, the laws of procedure too, well, we are sincerely looking at, and I can assure you, with the contribution of all, we would be able to deal with some of such areas of concern which are those areas which have been causing spokes in progression or blockades, or are providing some such methodologies to the persons who do not want a justice, the wheels of justice continuously proceeding or churning, to deal with those problem areas, remolding them, remodeling them. Of course, these are the tasks we always, we always continuously keep on doing, and we would be doing it. So I'm very sure in the coming days, the learned attorney has already given me that homework, and it's there with all of you too. So I would be inviting meaningful contributions, viewpoints from across the board, from everybody, from the senior lawyers to the law students, for the purpose of ensuring Indianization of Indian legal system, and of course certain such changes which are needed in the present days. We will be doing it. Thank you so very much. Jai Hind.
Thank you, Justice Maheshwari. Due to paucity of time, we'll be skipping, my friends, I'm taking her leave. If we can skip the concluding remarks and straight away come to presentation of the highlight of the day actually. May I request my colleague Saurabh Mishra ji to come announce the name of the awardees and a small background about them if possible.
Thank you, Majid. The esteemed members on the dais, ladies and gentlemen, without losing further time, we celebrate this Lawyers' Day as 3rd December, which was the Rajendra Prasad, the first President of the Republic of India. He inaugurated the Bar Association of India on 2nd April, and this being his birth anniversary. So last year's 2025 awards we are announcing today, and I have the privilege of naming the awardees one by one. To start with, I invite Mr. Dr. Aditya Sondhi. He is a senior advocate practicing before the Supreme Court and other high courts, and he is contributed in constitutional law, arbitration, professional ethics. Dr. Sondhi appears in matters of criminal and constitutional law. Next awardee is Mr. Dr. H.C. Upadhyay. Dr. Upadhyay is a distinguished legal professional and academic with an extensive career spanning over 5 decades. He is an accomplished scholar who has authored 4 books on contemporary legal issues and published 12 research papers. Dr. Upadhyay. Dr. H.C. Upadhyay. Our next awardee is Sri Mohan Katarki, who is a senior advocate and a senior colleague of ours, a very distinguished advocate who was designated by the Supreme Court of India. Mr. Katarki is a prolific speaker and writer on legal and constitutional issues, and he has worked a lot on international water law litigation. I next invite Ms. Preeti Suri. Ms. Preeti Suri is here. Please welcome. She is the founder and managing partner of PSA, a business law firm based in Delhi. Preeti has numerous accolades to her credit. She was named the Woman of Lawyer of the Year 2023. Congratulations. And last but not the least, Professor Rajiv Khanna. I have the privilege of inviting Professor Khanna, who was also my teacher in Campus Law Center. He taught me labor law from 1999 to 1993. Professor Rajiv Khanna. A privilege to me, as I said, as he had been my teacher in Campus Law Center. He has a teaching career, very rich teaching career. I congratulate all the awardees on behalf of Bar Association of India. Now I invite our awardees to kindly address this August gathering. Dr. Aditya Sondhi, to start with you. Kindly seeing the paucity of time, please.
Honorable Justice Maheshwari, the learned Attorney General, and all the office bearers of BAI, I firmly believe that peer recognition is always the hardest to earn. So receiving this award from the BAI means a great deal to me. I receive it on behalf of all of my juniors, past and present, and all staff and others who have been associated with my chambers over the years. I was an intern here 30 years ago under Mr. Dipankar Gupta, who's himself been an awardee some years ago. From him, I learned that proficiency as a lawyer is not enough, that you needed to also be a decent human being and an ethical professional. And I'm honored and I'm humbled by this recognition. Thank you very much.
Thank you, Sondhi, Mr. Sondhi. Dr. H.C. Upadhyaya, please.
Honorable Chairman of the Law Commission, Honorable Attorney General for India, President of the Bar Association, all dignitaries, my fellow friends and dear students. It feels good to be honored by our own association. My connection or association with this association is over 35 years. And in the profession, this has helped me to excel, because here every time several programs of national and international levels are organized. So it gives us an opportunity to interact with our fellow advocate friends. So this is a very good forum, and I would suggest all the youngsters, particularly the young lawyers and would-be lawyers, to immediately join this association and take advantage of it. It costs nothing. Thank you very much for honoring me.
Thank you. Thank you, Dr. Upadhyaya. Now I invite our very own Sri Mohan V. Katarki.
Chairman of the Law Commission, Maheshwari, Attorney General Venkatramani, President of the Bar Association, Prashant, and other dignitaries. At the outset, I thank Bar Association of India for giving me this award. I feel extremely humbled and very happily I accept this award on behalf of the teachers who taught me the law and my senior colleagues, that is my chamber senior, Sri M.C. Bandare, senior advocate, and two other lawyers who really contributed in the growth of my profession, that is Fali Nariman, with whom I spent nearly 5,000 hours of conferences, and Anil Diwan. Both of them were the president of this Bar Association for a long time. I also thank the very concept of idea floated by the Bar Association of India to honor the lawyers. Usually, the honors are given to the people who contribute to the society in a constructive way, but people forget that critical thinkers also have a role, or a bigger role, and these critical thinkers, which legal profession is the foremost, and the critical thinking which led to the people, leading the people for freedom movement ought to be recognized, and I'm so happy that this kind of a concept has been evolved, and I'm sure that many more will evaluate this. Thank you so much. Thank you all.
Thank you, Sri Mohan. Thank you. Now invite Ms. Preeti Suri, please.
Good evening, Justice Maheshwari, Attorney General, Prashantji, and everybody who's here. I don't really have a speech ready, but the fact is that amongst all the awards that I've received over the years, this one is truly special because it comes from my peer group in India, and it's extremely, extremely precious. I'm very honored. I'm also deeply honored to be sharing the stage with all the other awardees, but especially Professor Rajiv Khanna, who was my professor in law school. Thank you very much.
Thank you. Thank you. Thank you. Professor Rajiv Khanna, please. Also my teacher.
Justice Maheshwari and all dignitaries present. It's a long journey. Started teaching in '73. And many changes in legal education, legal profession, justice delivery system. But I've noticed that the Bar Council of India has introduced many changes for legal education. Internship for students, which I've noticed in 90% is a farce. Only a certificate is given. If your lawyer does not give, he had it. It's a reality. I'm of the opinion that further reforms are required in legal education. And I'll just toying with the idea that like every medical college is attached to a hospital, why not a group of law colleges be attached to some special courts, wherein young lawyers, budding lawyers will have not a paper internship, but actual knowledge of court practice and litigation. That they will have to study the case, not as students, but as budding lawyers. So, like medical education, legal education should also take this leap forward and open up. The seniors have to give the way. Another point, unfortunately, they say backlog. Where is the backlog in the district courts? What is that backlog as compared to the higher judiciary, the high courts, and the Supreme Court? Why this backlog at the higher judicial level? Something has to be done. One more point. Hard-hitting. Can a poor man afford litigation in the High Court or the Supreme Court? We have legal aid, but sorry, where is that legal aid for a poor litigant in the High Court or in the Supreme Court, or for that matter, even in the district court levels? It's very unfortunate. The legal aid lawyer behind the scene wants money from the litigant. Something has to be done in that. It's a reality. The lawyer provided for the poor litigant at the district level wants money from the poor litigant behind the scene. And if the matter goes to the High Court, in certain matters, the judgment has to be approved by the High Court. Even over there, the poor litigant, sorry, cannot get justice till such time he arranges money for the so-called lawyer. Many reforms are required. I will not take time. Thank you very much to the Bar Association. Thank you.
Thank you, sir. Thank you. And many congratulations to all the awardees. Please come for a photograph with all the awardees, please, on the stage, please. Kindly, sir, please come for a photograph, joint photograph. Let us have that privilege.
I'll request Yakesh ji to give a quick vote of thanks.
Because there's no time left. Thank you. We have to vacate the room. So thank you, thank you, thank you.
May I request everyone to wait to have a group photograph before you leave. Please come up, we'll have a group photograph.
जितने हो सकते हॉल खाली करना चाहिए